Good evening, ladies and gentlemen, and welcome to the February 11th meeting of the City of Tampa Variance Review Board. My name is Gary Brown, and I'm the chairman this evening. From my left, the members of the board are
Dustin Pastor,
Brett Feldman,
Lynn Hertak, Sam Walker,
Susan Long.
also in attendance this evening are Assistant City Attorney Kate Wells, and from Land Development, we have Roberta Meade Curry, and from Natural Resources, Brian Knox and Brett Burks, and from Transportation, Jonathan Scott. I'll take just a few minutes to review tonight's procedures. Cases will be called in the order that they appear on the agenda. When your case number and the applicant's name are called, please stand in either aisle to the side of the room to acknowledge that you are here. Staff will then give a brief introduction to the board of each application. When you approach the podium, please speak into the microphone and state your name, address, and if you've been sworn in. You'll hear me say this 9 times tonight. The applicant and/or their agent will have 10 minutes to give testimony, present witnesses, and documentation as a part of their presentation. This is your time to present all of your evidence. Anyone in the audience wishing to speak in support of or in opposition to the application will then have 3 minutes each. After that, the board may have an opportunity to ask questions regarding the application. Finally, the applicant will have an additional 5 minutes for rebuttal if needed. The time periods as stated will be kept by the chair. Any information such as pictures or plans that have not been previously submitted as a part of your petition and you intend to present at this hearing for consideration in support of your petition must be individually presented and accepted by the board. After acceptance by the board, you must submit the item to staff for it to be entered and made a part of the permanent record. The board bases its decision on competent and substantial evidence which is presented this evening and which meets the criteria required by the city's Code of Ordinances. The variance granted by the board will be only for what is shown on the site plan and will be compliant with any terms and conditions stated in the approval by the board. You must have 4 votes for the variance to be approved. If an insufficient vote is obtained, the case will be automatically carried over for consideration at the board's next meeting. If approved, your variance will expire 2 years from today's date. All other city codes will need to be met. And I do want to point out that we could have cases tonight where there may only be 5 or 4 board members voting, so we'll remind you of that if that's the case when your application comes up. If your case is continued, it will be continued to either the March 10th or April 14th public hearing dates. Are we good on those, Roberta? You want to do it now? Okay, go ahead.
Roberta Curry, Planning, Design, Development Coordination. March agenda is full.
Okay.
April agenda has 6 to 8 cases so far.
Okay.
Okay. And I do have to remove one case from the agenda, but,
Yeah, you can do that when
You
we
wanna do
get
that
there.
now?
Well, yeah, sure, if you
Okay.
want.
all right, VRB 2017 was posted for the agenda, but it decided, and per staff review, to pull the case, and they have to renotice, and they will more than likely be placed on the March agenda if they,
Did you say 17?
yes, VRB 2017.
Okay, it's not on the agenda.
No,
It's
it
not
was
on the
pulled,
agenda. Okay, it
so-
was already pulled.
Yes,
Okay, thank
in
you.
case you were looking for it.
Okay. Okay, if you wish to appeal the Variance Review Board's decision to City Council, you must file a petition for review of a board decision within 10 business days of the decision. If your variance is granted, you will not be able to pull any permits until after the 10-day appeal period has passed. Your cooperation will ensure that this meeting runs smoothly and will be greatly appreciated. Before we begin the first case, is there any business regarding the agenda that staff would like to address? You're good? Okay, thank you. Do you have anything you want to tell us, or?
Yes, Mr. Chairman. At this time, I would like to ask the members of the board if they've had any ex parte communications with anyone that will be appearing before them this evening or on any matters that are scheduled this evening. If those communications were verbal, please disclose the sum and substance of the communication and who you spoke with. If in writing, if you could submit a copy of those written communications for the record. So seeing none, I think we're good to go.
Okay.
Thank you.
With no further business to discuss, is there a motion to approve last month's minutes without objection?
I so move.
Okay, is there a second?
Second.
All in favor say aye. Aye. Any opposed? Nope. Okay, so the minutes are approved. We just did the ex parte. At this time, all persons who will be present, presenting evidence or testimony to the board shall rise and be sworn in. So if you plan on speaking and you're not sure you're going to speak, stand up anyway.
Please stand and raise your right hand and be sworn in. Do you swear or affirm that the testimony you give this evening will be the truth, the whole truth, and nothing but the truth?
Yes. Okay, Miss Roberta, we're ready for the first case. It's a continuation of VRB 2001.
Yes, basically unfinished business on the agenda, and the case remains closed as of this evening. It's VRB 20-01.
So, Mr. Chairman, with this matter, since it was continued from last month due to an insufficient vote, it is your prerogative whether you would like to go straight into the vote or open the public hearing to take additional testimony.
First, I want to ask, are there any board members that might be recusing themselves from this case? Because we had some before.
Yes.
So Lynn is and Dustin is? Okay, so you'll need to go ahead and, if you're recusing yourself, you get to go to the other room. Go away. Okay, now,
So we have 4 board members.
Right.
We have a quorum. Under the VRB's rules of procedure, if we only have 4 board members available to hear the case and take action on it, the applicant, as of right, may request a continuance. If that request is made, then this item would be continued for 2 months out, so we'd be looking at the April
Okay.
meeting.
all right, Roberta, I'd like to ask the applicant if they want to have this heard tonight or if they want to continue. Applicant, please come forward. Don't forget to state your name, address, and if you've been sworn.
My name is Aaron Murphy. My address is 3902 West Take-On Street, Tampa, Florida 33629, and I have been sworn in. In an effort to get this behind us, we would like to move to a vote and not be continued.
Okay, all right. Pardon? Yeah, no, he does. Okay, Mr. Murphy, you can sit down. I believe the board has heard sufficient evidence on this application, and we don't need to hear a staff review, and I'm going to go right to a vote. Is that?
Maybe Roberta.
Yeah, I don't mind you asking Roberta, but I really don't want to get into a public discussion.
I'm not going to.
If I may, if the board is going to ask questions of staff, you are going to have to open the
Oh,
public
there you go.
hearing to take that testimony.
Is it a procedural question, or?
I want to know if he is denied, the impact, does he have to take out the concrete slab and the tent, or just the slab, or just the tent, and what impact that will have on?
Well, it's a code violation case, is it not?
That is correct.
Right, so, I don't know the specific answer to that, but he'll have to do something to remedy the code violation.
I guess my question is, would that be worse than what he has now? I don't know.
Well, I want to be sure you're all comfortable to make a vote.
Yeah.
Are you?
Yeah, I'll make
Okay.
a vote. I'm not
All
sure
right,
I'm gonna like the
okay, then
results.
I'm not going to open for public discussion and hearing. I'm going to go ahead and ask for a vote. I need a motion for approval or denial.
All right. I move that variance for case VRB 20-01 located at 6915 North River Boulevard be granted as depicted on the site plan presented at the public hearing for to vest the existing conditions of an accessory structure based upon the applicant presenting competent and substantial evidence in the record and at this public hearing and the public hearing on December 10th, 2019, and the public hearing on January 14th, 2020, of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 27-80 of the city code. Specifically, that the applicant has demonstrated that given the property line and the slope going down into the river, that this is not a self-created hardship, it's something that has developed over time. And further, that if the variance, if granted, will not substantially interfere with the injury, the health, safety, or welfare of others whose property would be affected by the allowance, because we've seen evidence that the neighbor directly across the street who would be most impacted, or excuse me, across the creek who would be most impacted has supported this variance. And also we've heard evidence from the city that there has not been any adverse environmental effects.
Okay, we have a motion for approval. Is there a second?
I'll second.
Okay, Mr. Feldman has
Do we want to make an
seconded.
amendment to that?
I'll open it up for discussion now.
Okay.
What would you like to say?
Because you didn't mention reducing the wetland setback from 25 to 7.
I'm sorry, yes, that,
I'd like to add that too.
Yes.
yes,
Okay, so you accept that amendment to your motion?
I do.
Okay, all right, so we have a motion for approval and a second for approval. All in favor, say aye. Aye. Any opposed?
Aye.
You're opposed? Okay. You get to come back in 2 months,
Oh, geez, I didn't think of that.
okay? All right, Ms. Mead, next case. Give our other board members time to come back. Okay, ready to hear VRB 20-07.
Okay. Good evening, Roberta Mead Curry, Planning, Design, and Development Coordination. The address is 1513 East Anona Avenue. The code section under review this evening is 27156. The applicant is seeking to reduce the front yard setback from 20 feet to 10 feet. Applicant is seeking to vest existing conditions of primary structure due to a lot split and the conditions set forward in formal decision FDN 1987. The formal decision is attached to your record and for your review, and the conditions are outlined. The property is zoned RS50, and the Hillsborough County Property Appraiser information is included in your record. Right-of-way has found it consistent, transportation and natural resources has found it consistent, zoning has found it inconsistent. This is the formal decision. Page 2. And the conditions are outlined on page 2, which states that if they can't meet the criteria, they must seek a variance. That's why they're here tonight. Property appraisers information. Variance map. Again, the property is outlined here in red. Anona is here. Side street is 16th. All these surrounding properties are RS50. Front of the property. Front looking at the corner. Front looking from the corner. Same picture. Side yard. Looking north down the side yard. This is looking down Highland Avenue. Looking north on Highland. Looking east on Anona. Again, this is the subject property here. Looking west back on the corner. And again, further down Anona. Site plan. Again, the original lots, or the original lot was this property here. This portion was split off and the existing house is remaining. Therefore, the lot front is now here with the existing house sitting here. Corner yard, side yard, rear yard.
Whoops.
So by nature of the house remaining, the compliance to meet the front yard setback for RS50 was 20 feet. Because they're keeping the existing house, it doesn't meet that. Okay, so that's why they're here asking for the variance. I have no further information entered into the record. I'm here for questions.
Seeing none. Applicant, please come forward and state your name, address, and if you've been sworn in.
Good evening, my name is Juan Carlos Castillo. I am the applicant for BRB 2007. The address is 1513 East Anona Avenue. We would like to let you know this is not as a result of a code violation. It's as a result for a condition for a formal decision to split the lot. And we would like the variance to be granted. As a result, we will gonna be able to build a new single-family residential and increase the jobs on the area and build a new single-family house for a new family. So I would like the variance to be granted. Thank you. Do you have any questions?
Well, you have 10 minutes for your presentation, and then we'll hear from the audience if there's anyone who wants to speak, and then we'll ask questions at that point. So do you have anything else you want to tell us, stating hardship conditions?
Mostly say everything already. It's just to reduce the front setback from 20 feet to 10 feet, 10 foot, 10 inches.
Okay, the board understands that, but what you need to give us are the hardships that don't allow you to change the physical condition. In other words, why can't, you gotta tell us why.
The hardship is, we will be able to do if the rear setback, it will be 20 foot, but due to an existing part of the house that is there, and we don't want to demolish the garage of the house. So we are here as a result from zoning. as a condition to allow us to split the lot to build on the adjacent lot, a new single-family residential.
Okay, so that's all
It's
you
only
want to share with us?
It's only 3 properties on this block, and the owner is gonna own 2 of them. The other property is facing to Highland Avenue. So we only have, it's only gonna be 2 houses on this block facing to 16th Street.
All right, is there anything about the lot itself, any conditions of the lot that make it unique or different than other lots in the same neighborhood?
The only difference is gonna be the reduce on the front setback from 20 to 10. The lot is zoning RS50, and the setback is 20 on the front, 20 on the back, and 7 on the sides. And the lot that we split, that we are trying to have the intent to build a single-family house, is okay with the zoning regulations. We build a house, gonna have the 20 in the front, 20 in the back, and 7 on the sides.
Okay. All right, is there anything else you'd like to say before I ask for audience members who might want to speak? Is that it?
Yeah.
Okay. Step aside. Is there anybody in the audience that would like to speak on this application, either for or against? Okay, seeing none. Board, questions for the applicant and or staff? Okay, you have 5 minutes for rebuttal if you want it. You don't have to take it. Come on, back up to the podium.
I'm okay.
So, I mean, because we've heard this,
Yeah.
in the past, or I mean, anyway. So is there anything else you want to add
No,
before I
that's it.
close the public hearing?
No.
Okay, all right.
Thank you.
Then I'm going to go ahead and close the public hearing. Board, what's your pleasure?
Is he the one that separated the lots? The applicant, or did he buy it after they were separated? Can they know?
He testified
He separated.
that they separated the
That's
lot.
what I thought.
Yeah.
Okay.
Mr. Chair,
Yes.
Mr. Feldman, I'll make a motion. I move that the variance request for case VRB 20-7 for property located at 1513 East Monona Avenue be granted as depicted on the site plan at the public hearing to reduce the front yard setback from 20 feet to 10 feet with encroachment for eaves and gutters based upon the applicant presenting competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 27-80 of the city code, specifically that the lot split has changed the positioning of the front and side lots such that the new front yard was previously the side yard. The house is remaining on the property, and the practical difficulty of removing the house or modifying the house's setup it creates that hardship.
Okay, I have a motion for approval. Is there a second?
I'll second it.
Okay, we have a second by Ms. Long for approval. Is there any discussion? All in favor say aye.
Aye.
Any opposed? Okay, you've been approved 6-0.
Thank you.
To 0. 6-0. Okay, staff, next case is VRB 20-03.
Roberta Mead Curry, Planning, Design, Development Coordination. I have been sworn. The address is formerly listed as 1500 West Platt Street and 302 South Dakota Avenue. It is also known as 311 South Dakota Avenue. New address will be 302 South Dakota Avenue. The section under review this evening is 27-283.7. The applicant is seeking to reduce the required parking spaces from 10 spaces to 0 spaces. The applicant is seeking a new business which requires change of use, change of intensity, and change of occupancy. Applicant is in process of remodeling and upgrading existing building to a new business, which requires permits. Project has been cited under a code enforcement case CMP 20-359 and code enforcement case 20-148. The property is zoned CI, commercial intensive. The Hillsborough County Property Appraiser's information is contained in the record for your reference. Right-of-way has found it consistent. Transportation has found it inconsistent. Natural resources consistent. Zoning inconsistent. And Jonathan Scott and Brian are both here if you have questions of them. This is the property appraiser information. Again, there are two structures on the property. This being the small house when you see the photos, and this being the larger piece where the business is taking place. Business is taking place basically in both structures. This is the last piece of that. Variance map. The property is located here in red. This is, what street is that? That's the railroad. Sorry, it's hard to see. And then this is Dakota, or Platt Street, West Platt, I'm sorry. And this is Dakota coming through here, and it dead ends into the railroad, and this is the crosstown. There is a PD here and here. The rest of the properties through here is CI. I have another PD back here. View of the front of the property. And again, that's the smaller structure. View of the second structure and looking down Dakota to the dead end and the crosstown here. Closer view. We have some information regarding this structure here. Side view looking down Dakota from across the street. Looking down Platt to the east. Whoops. Looking down Platt to the west. Looking down Dakota to the north. Again, this is standing at the dead end looking back up to Dakota. Looking at the CSX Railroad, again back down to Dakota. On Dakota. And then this is, again, the other side of the CSX right-of-way and the corner of that one structure. Site plan. Again, the smaller structure here, larger structure with the repair bays here, CSX Railroad here. I have nothing further to add to the record, but I do have some information. If you are going to consider approval, we would want to discuss. That later.
Any questions for Mr. Kurt Mead? Okay. Applicant, please come forward, state your name, address, and if you've been sworn in.
Thank you, Mr. Chair and board members. My name is Jim Porter. I'm an attorney with the Ackerman Law Firm, 401 East Jackson. I have been sworn. I'm here tonight representing the applicant. If I could briefly go over sort of orienting you again to the property and just highlighting a few points, sort of supplementing what Roberta said. This is the property here. It's a small triangular shaped piece of property. Platt Street, Dakota, railroad tracks, and crosstown. What I wanted to highlight were a couple things. This is a dead-end road here. Dakota's dead end. The uses in the immediate area are both self-storage. Across Platt Street is self-storage, and across Dakota is self-storage. This is the use across Platt. this is the use across Dakota. Why that's important, those are both passive uses that have adequate parking. They don't generate parking like a normal business would, like a restaurant or other types of commercial use. There are 2 buildings on the property. This was built in 1944. And the other piece that Roberta mentioned, where the auto body repair function is being used, was built in 1960. You may recall, board members, that this property was used for a very long time as a furniture restoration business, and it was there for over 50 years. It's always been sort of a commercial use. Again, Dakota is a dead end that you can see here. I want to go through the criteria of the variance. This is a situation where we technically need a variance even though there is parking on site. As you can see, the 4 bays each count as parking spaces according to your code, and there are parking spaces in front of this structure. However, because those parking spaces back out onto Dakota, they back out onto a right-of-way, they cannot be counted as parking spaces per your code. So there are parking spaces on site, they can't be counted. That's why we're asking for a variance from 10 required parking spaces down to 0. I worked with staff on having some of them count and having a lesser variance, but the advice was we can't count those spaces, so that we need to seek the variance for the entire parking spaces. I will note that there are parking spaces also on Platt Street, and again, if you are familiar with that section of Platt, because the businesses nearby are self-storage, they aren't the restaurant or the bars further down that way on Platt. So there's plenty of parking, but they're just not allowed to be counted, which is why we're here. I want to go through the variance criteria one by one. We do need this variance because of the unique hardships of the property. The property has been a commercial piece of property for over 50 years. It's a strange triangular shape. Part of the property was taken when the Selman went in, and so they're left with not a lot of room to navigate there. The property location, given the dead-end street and the Selman and the railroad track, is something that is unique to this property. The configuration of the building and the property were existing. The applicant didn't create the situation. Again, it's been a long time business there, and it's CI, it's a very intensive commercial use, and this is a good use for it there. The property configuration was there and created in part by the taking for the crosstown. The immediate uses in the area are self-storage, and they are adequately parked, and as I said earlier, they don't generate a lot of parking needs, and so no one is going to be harmed in the immediate area by allowing this variance to take place. There won't be spillover parking into the self-storage areas, and the parking on site is existing, just not allowed to be counted. The property has been a viable business for over 50 years, and it's a good use for this particular piece of property, given the railroad tracks, the crosstown, the dead end, and the other uses there. Auto body repair shop is a good use. The other piece of that, this use that's important to recognize is because of the nature of the business. Customers drop their cars off and leave, and then they are worked on and they come back. So there's not a need for, again, like for a restaurant use, for instance, where you're going to have customers coming throughout the day. The hours of operation are 8 to 5, so it wouldn't compete with any other of the uses further down on Howard. Again, finally, this has been a viable business, and this is a suitable spot for it. The property is zoned commercial and has been for a very long time. The particular use is a perfect fit. The immediate area is self-storage with adequate parking. Again, there are actual spaces on site that can't be counted technically, but that we're not going to be creating a problem. We're not aware of any opposition to this, and we would respectfully ask for your approval. I would like to submit these photographs into the record if that's acceptable to the board.
Yes, please, if you want to, so the board can take a look at them.
I have nothing further to present, and I respectfully ask for your approval. Thank you.
Okay, thank you. Is there anyone in the audience that would like to speak on this application, either for or against? All right, seeing none, board, questions for the applicant, Mr. Feldman, or staff?
I have one quick question for the applicant.
Mr. Porter?
Mr. Porter, you talked about the on-site spaces, you showed pictures of them. How many of them are there? I counted, looked like 4, but
On site there, so in front of the house there are 4 spaces.
Okay.
And the other piece that is important under your code, the bays are allowed to be counted as spaces too, so that would be 4 additional spaces. Again, those cannot be technically counted, but they're there.
Thank you.
Ms. Long?
I have one question for you. Does this business have any agreements with the 2 self-storage businesses that they're allowed to use their parking lots for their businesses?
No.
No, so if the Orange Self-Storage Place, whatever that is, decides one day they don't want you there, they can just put a fence around it and you can't park there. Am I correct?
Correct.
Okay, that's what I wanted to know.
We're not, and Ms. Long, we're not counting those, that was not part of my argument that we would count those spaces. My only point in referencing the self-storage is they have adequate parking for their use, and we would not be impacting them by this variance would not be impacting them, but we're not counting on using those spaces as part of our argument at all, and we don't intend to.
Mr. Pastor?
You said this business has been in this location operating for many years.
Not this business, no, a commercial business. This is relatively new.
Was it a garage, do you know?
No, it was a furniture repair,
you said that.
restoration
Okay.
operation. They did antiques, they had paint booths. It was a very intensive use there. This is similar use, but probably not as intense.
And you haven't, I mean, obviously nobody's here to protest, so that's a good thing, but you haven't received any type of comments from the neighboring businesses or anything?
No. And we had, just for your record, we had intended to go forward in December, so we had noticed this earlier. We kept working with staff until we got to this point. So it's been out there for quite a while, both posted and written notice, mailed notice, and we haven't received any sort of objections to it.
Roberta, I think you said you had some things you wanted to share with us.
I just want to clarify, and I guess maybe what the applicant is trying to say. This is where he would have the repair bays, and the drawings that we're seeing, he has 4 repair bays here, 4 garage door openings. So again, for each repair bay, it's required 2 parking spaces. So he would have 1, 2, 3, 4 parking spaces in this building on his property boundary. Everything else can't be counted, okay? Also, we have, if you're inclined to approve this, staff had some recommendations that we wanted to enter into the record. Again, the reason we are asking for the conditions, this structure here, again, for right-of-ways review, they asked for that structure to be removed along with the fence, because as you can see, it is in city right-of-way and may be in a portion of the CSX railroad right-of-way. Okay, and anything that else is encroaching into CSX right-of-way, we need that to be removed at time of permitting or show on their plans at time of permitting. They do have to obtain permits. They will need, like we said, change of use, change of intensity, set of permits done. And then what we're seeing out there is there are some impacts into the neighborhood where we are seeing parking in the right-of-way, parking in the CSX right-of-way, and parking on the street. If they're dropping off the vehicles, we're wondering where they're dropping them off at. So 3 and 4 are kind of addressing what we're already seeing as impacts to the neighborhoods and parking in the right-of-way. And I think this one, here's the opposite right-of-way and on the property. So our suggestion too is if there is a situation where they might want to enter into a shared agreement, then they go ahead and put that into the record as part of the permitting drawings as well and get that to land development.
Transportation, is Mr. Scott here?
I have a question for her.
Wait, hang on, Mr. Scott. Justin, you had a question?
I had a question for Ms. Mead.
Ms. Mead, could you come back?
The variance in front of us is for parking spaces, so I don't believe we have purview over the shed or fencing, correct?
Right-of-way comments did include that it be a condition of the item has to move. It's in the right-of-way. It can't be there.
So then that doesn't,
It would have to be shown to be removed at time of permitting. I mean,
okay, so that doesn't affect us then? Like, we don't have to comment on that in any regard, because right-of-way has already made that comment, and it will have to be addressed at permitting. Therefore, there's no need for us to address it.
Well, it's on the site plan, so we're making sure that we all understand that we're not approving that item on the site plan.
Okay.
All right, Mr. Scott. Ms. Mead, in her staff report, said that transportation had objections or problems. So can you tell us what they are?
Sure thing. Jonathan Scott, Transportation Planning. Transportation typically objects to any parking waivers. So that's just a standing objection we would have since they're asking for a parking reduction.
Okay, and that's just the basic, simple thing.
Yeah,
there are no particulars of this particular application that are concerning to you?
No, I mean, it's a quiet little street. I mean, they're doing their best to comply. I mean, they do have some parking, like he was saying, that you can't count them, so it's for a unique circumstance. I don't really see an overflow problem to the neighborhood or, you know, a nearby thing, but transportation would still have an objection just for any kind of parking waiver requested.
Right, and that's causing them to come to the VRB. We get that. Does the railroad have a right of access at the dead end to the tracks?
Yes, they could access their tracks through that right away.
But I mean,
Absolutely.
do they have a right, a legal right to go there? In other words, could they be counting on this dead end road, this quiet dead end road, for some significant access?
They could count on that, yes. That's certainly,
Okay.
it does access their tracks, so
Okay.
CSX could use that. It's an open right away.
Have you or any other staff members had conversations with the railroad regarding this application?
No, it's an open right away, so it's really of no concern. If for some reason it was closed off, they would object. Otherwise, it's an open right away, so they can use it for access. But we have no communication with them on this.
Okay. It's been testified that this is an auto body repair shop. I can ask the applicant the question. I'm looking at the pictures of all the cars that are parked there, and they all look to be fairly expensive cars, whether they're new or used.
Mercedes and BMW.
If you're not at the mic, please don't comment. Whatever. So, Mr. Scott, I didn't mean for you to get away. As we've heard testimony, people drop their cars off. I'm trying to understand, besides the on-site parking, wouldn't there be a security issue here for the protection of those vehicles? If they're, and I don't know if they have more cars than in these pictures or fewer, or if this was a busy day or what, and we can ask the applicant. But, I mean, whose purview would that fall under? Because we do hear cases, as you know, regarding fencing on auto lots, for, anti-theft and burglary issues, and yet that's not in front of us tonight. So I'm going to ask the applicant my next question. That's all I have, unless if you have something you want to add.
That's all I have.
Okay, thank you. Mr. Porter, this board does hear variance requests for things like fencing around auto shops. I'm trying to get my head around the business use, and that's not what we do. It's not up to us to say you can have that business or you can't. But I just don't understand how someone drops off their Mercedes and it's parked in the open like this. Can you shed some light on that?
Well, a couple things. One, yeah, and I might have the applicant come up and address that, but I mean, that is sort of a business issue, not a variance issue. The conditions were just presented to me tonight. I was not aware they were going to be,
Okay.
so I'm trying to process them. I agree with Mr. Pasteur. The issues with things that are in the right-of-way are really not before the board tonight. We are working through our permitting issues. They've gone in for a change of use. It's obviously a new use after a very long time use, and so there are permitting issues that we're working through. In order to get the permits, we need to get the variance.
Right.
So we're sort of in a loop, and so some of these things will be addressed. If I could ask about security, are you comfortable addressing the security of the cars? Yeah. This is the owner of the property, and if he could answer your question.
Okay.
But again, I would just ask the board to really focus on the variance request for the parking, and we're happy to be helpful with that, but it is, you know, it's the responsibility of the applicant to make sure the cars are safe
Right.
if they're left there.
Right.
If you, can you address the security of how you deal with that?
Please state your name and address, and if you've been sworn in.
Ed Coker, I have been sworn in. It's 1500 West Platte, even though there's a lot of different addresses
Okay.
on there. We're not a body shop, though. We're a repair shop.
You're a repair shop,
So most of the cars are coming and going quick.
okay?
Some cars are disabled that we move around. I think some of those pictures are cars that we're in the middle of, pull them out, park them. The ones at the end, they're leaving. They're no good.
Okay, so, again, you know, the parking issue is, the request is 0.
Yeah,
And there's all kinds of testimony and documentation that you're in the right-of-way regardless of, even if you had 10 spots.
gotcha.
It looks like you'd still be parking in the right-of-way, which you have a right to do. I don't think that's been testified that you don't. Even transportation acknowledged that Platt Street has some on-street parking. But I'm curious, are there cars left out overnight in this operation?
In the parking spots, but not in the street.
Okay,
So, yeah, including my own. We've never had in South Tampa an issue. I mean, we did this on Davis Island 14 years. We were on Tampania 3 years. We've never had a problem.
okay. This is a different part of town.
Yeah, it's nice. I mean,
Okay. Anybody else have any questions for the owner while he's up? Okay, I'm done. Thank you very much.
thank you.
Mr. Porter, I'm sure you're going to address this in your rebuttal, but I figured I might as well refocus to address it now. The photographs that staff showed of the cars out and about, that's not a typical condition?
I think as the owner said, as Mr. Coker said, the cars are kind of there and then they go there. And I'm not sure when the photograph was taken. I submitted photographs that show something different. I think it's just the nature of the use is the cars come in and out throughout the day. And I don't know that there is a typical day with that like that.
Mr. Tester?
This could be for Mr. Porter, and if not, maybe Ms. Mead. Was the CSX rail line part of the notice? Do you know?
Oh, I believe so, yes.
Okay. Just wanted to point it out. If they would
I
have
could
had
check the
any,
notice, but that's.
they would have had any issues, they could have voiced them.
Right.
Ms. Walker? James? Okay. Mr. Porter or Mr. Coker, how many employees are there on a full-time basis?
4.
4? Okay, all right.
Counting us. 2 mechanics and us.
Okay,
Just a husband and
okay, no, you said 4. That's-
Just for the record, it's clear, there are the husband and wife and then 2 additional employees.
Okay, thank you for clarifying that. Ms. Mead, do you have something?
Just for the record, CSX was the first one notified.
Okay, thank you very much. Any other questions for the applicant or staff?
I actually do have a question, probably for the owner of the property, but can you tell us how many cars are on the property, like on an average day? How many, I know you said that some of the cars stay overnight.
Mr. Coker, you've got to answer it at the podium. You have to be on TV.
That's okay. Typically, I would say on the property, 10 to 12.
Cars in a day?
Yeah.
Okay.
Some come quick. We diagnose, fix something fast, and leaves. And some make appointments, come back, leave. Also, at night, we put all the cars up in the air and put them underneath and close the doors.
So only
So we
4
have-
cars stay
We
overnight?
fit about 8 inside.
Oh, okay.
I mean, we try to pack them away the best we can.
I hear you. Okay.
Yeah, and another thing too, CSX works at Platt Street. They never work down there. We see them daily, but they do work on Platt and right there, right where the things come down.
Okay, yeah, I got it.
Okay, thank you very much.
Thank you.
Any other questions? All right, seeing none. Mr. Porter, you have 5 minutes for rebuttal.
Just very briefly, board members, I think the discussion was a very good one tonight. This is sort of a different type of use. We are going through the permitting process. We're trying to address some of the issues that staff raised. In order to get the permits properly done, we need to have the parking situation resolved. Because of the situation of the way the property is has developed over the years with the crosstown, with the one-way street, and with the shape of the property, we're really limited as to what we can do. The use itself is a good use for the property. No matter what goes there, what kind of commercial use is going there, you're going to have a parking issue. Of all the things that could go there, this is probably the best use because of the nature of the use, with cars being dropped off and coming in and out. So we will work through the other issues that are raised by staff with the right-of-way, and we respectfully ask for your approval.
All right, thank you very much. Without objection, I'm going to close the public hearing. Board, what's your pleasure on a motion and or discussion?
I have some thoughts about this. So I guess one of my first thoughts is that if we decide to approve this variance, I think that it should be on the condition that any significant remodel requires that they comply with the parking. Because I think one of the concerns I can see is if they do a complete tear down and they're not required to have any parking at all, then that could potentially present a problem moving forward.
I don't believe we can condition it that way because it's tied to the site plan. But we'd have to.
But if there was a significant change to the footprint, they'd have to come back, would they not?
If the board were to approve the variance that is before you, it would be tied to this site plan, this use. If they were going to go through another change of use process, if they were remodeling, if the footprint changes, I would expect that that would trigger another review. So this would be limited just to the conditions as they exist today. I would caution against granting any conditions that are intended to impact future development, as that would be addressed at that point in the future.
Okay.
Thank you very much. Anybody else have any discussion?
So, well, there's no further
or you
discussion.
can make,
I'll
make a motion, we can discuss after the motion.
I move that the variance request for case VRB 20-3 for property located at 302 South Dakota Avenue, aka 311 South Dakota Avenue, 1500 West Platt Street, be granted as depicted on the site plan presented at the public hearing, to reduce the required parking spaces from 10 spaces to 0, based upon the applicant presenting competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 2780 of the city code, specifically that this is an oddly shaped property, a small triangle shaped property resulting from a taking back when the crosstown was installed, that the property is bordered by a dead-end street and a railway, and that there are on-site parking spaces that do not count. We have 8 on-site parking spaces that don't count per the city's regulations. However, those parking spaces all back out onto a dead-end street. And because of that, I feel that it meets the hardship criteria.
Second. All right, we have a motion for approval by Mr. Feldman and a second by Mr. Pastor. The only comment I want to make is that unlike a auto repair shop where you could have obviously some cars on the street overnight, a furniture repair shop, they're not going to leave the furniture outside, and everybody goes home at night and there are no cars on the street. So I don't know how this would be less intense, as we heard testimony-wise. That didn't make sense to me. But saying that, I don't have a problem approving this myself. So all in favor say aye.
Aye.
Aye. Any opposed? You've been approved.
Thank you,
6
board
to 0.
members. Appreciate it.
Okay, next case is VRB 20-06.
Roberta Mead Curry, Planning, Design, and Development Coordination. I have been sworn. The address is 4523 West Fig Street. The case, the code section under review tonight is 27-290. The applicant is seeking to reduce the corner yard from 7 feet to 2 feet, reduce the rear yard from 3 feet to 7 inches for accessory structure number 1, and reduce the east side yard setback from 3 feet to 8 inches for accessory structure number 2. The applicant is seeking to reduce the setbacks for existing storage sheds in the rear yard. Variance would vest the existing conditions of the shed. The property is zoned RS50, and the property appraiser's information is contained in your packet for reference. I do have an item from right away. They submitted that the alley has been vacated. And that the easements from the alley have been released. Variance map. Again, the property is here. Fig is along this direction. Trask is here. Several PDs in the neighborhood. RM24 across the street. Residential office here. Another PD. The remaining in here is RS50. Front of the property. Front along Trask. Looking back down Fig. Again, this is the residential multifamily across the street. Looking down Fig to the west. Fig to the east, Fig Street to the east. Again, front of property on Fig. Looking north along Trask. South along Trask. Site plan. Again, this is accessory structure here and accessory structure here. The one that is asking for the 8 inches is accessory structure number 2. This being accessory structure number 1. Existing house is here. I have nothing further to add to the record. Oh, sorry, yes I do. Sorry. I have letters of support. Sorry. This is Evalu Nichols, Grand Oaks Townhome Association in support. Another email from a neighbor in support. That's it.
Okay, thank you. Applicant, please come forward. State your name, address, and if you've been sworn in.
Hi, my name is Amy Gaddy. I'm at 4523 West Fig Street, and I have been sworn. This is Robert Biddle.
Robert Biddle, 4523 West Fig Street, and I have been sworn in.
Okay.
He's a co-owner. Basically, we purchased this property in 2017, and these structures already existed, and we're requesting a variance to keep our existing structures, to just not move them. They've been there since 1988. There hasn't been any water problems, any problems from the neighbors, any natural resource problems. And we have the Grand Oaks is the townhome directly behind that is in support. I also have letters, 10, one for everybody.
Okay, would you like to submit those to the record?
Please.
Okay, go ahead and do that now.
This is from the neighbor on the east side where the shed abuts and is in support. Excuse the broken English in her email, please. But it would significantly reduce our enjoyment of our property if we, and our storage, to take these structures away. They're very substantial structures, they're not whimsy, is that a word? They're not frail structures. They're substantial, we use them a lot, and they are, they're, don't want to say electrified. They're, they have electricity, they're substantial. We have our pool equipment is hooked to our shed, so that's another, would be a hardship to move all of that.
You still got time.
Anything else
Yes.
that, let's see.
It's your time to use.
Let me check my notes. I think I've pretty much covered it all, thank you.
Okay, did you want to add anything, or no? Okay. You can step aside. Is there anyone in the audience that would like to speak on this application, either for or against? Okay, seeing none, board, questions for the applicant and or staff? Seeing none, applicant, you have 5 more minutes if you need it.
Thank you.
Well, actually, hang on, come up, I'm going to ask one question. Do you have any photographs of these sheds?
We do.
Okay, I think it would be, you're telling us that they're substantial, but that doesn't help
Right.
us.
The, and I was hoping that I could show you. Get it. I should have got a hard copy, sorry. So this is from Big Trask, which is facing the front of the house. It's odd, our address is odd because when the house was built in the 70s, the door was facing Fig. Now it's facing Trask, so there's some confusion with the pizza guy for that.
Okay, the
to
picture
get
that
address right.
the picture that is up right now, you mentioned the pool equipment is attached
This
to
is
it.
the shed with the pool equipment. Thank you very much.
Okay.
And that between the shed, the door, there's another little right there. The house is to the right, and the fence on the east side is behind the shed. That's for
Okay.
storage and lawn equipment.
Okay, the roof of that shed, can you describe it? Which way
It is
does
a
it?
slant roof, and
So-
that was actually re-roofed when we had the roof done when we moved in.
Okay, but it's slanting towards where? The property?
Towards the
property line or inside the property?
It's inside the property.
No, the bottom of the slope, is it closer to the property line or on the door side? Can you point to it? Because I see a little bit of the roof. Yeah, is that the low end of the roof?
Yes.
Correct.
Okay. Which
Yes.
is next to the property line, correct?
Correct.
Okay. Is there a gutter on that?
No.
Okay. And the neighbor, the letter of support is the neighbor that lives
Yes,
on
sir.
the other side of that fence?
Yes, sir.
Okay.
Yeah.
All right.
And we've been there almost 3 years and haven't had any water issues at all.
Okay. It was hard for me to see the pictures of the other shed. Could you find is
Yeah, the
this
gazebo.
your best one, maybe?
The gazebo is that's not very good.
So it's an open gazebo on all 4 sides?
It's screened in, mm-hmm.
Screened on all 4 sides?
Mm-hmm.
Okay, so a place to...
With a shingled roof, and it's
Okay.
in the ground. We even considered moving it a little, like 2 feet, and it's so we've had several people come by to consider, and they said it's in the ground, and it's
It's like a deck.
Okay.
It's a room with a bench, built-in bench in there.
Okay, again, it's hard to see. Is this roof a four-sided roof or a two-sided roof?
It is four.
Four, okay. So it's what would be called a hip. That's a hip roof.
Yes, it is.
Okay. So it drains to all four sides.
Yes.
Does it have any guttering on it?
It does not have a gutter, and we, again, have no issues. I mean, as between the fence and the roof line, our property has the sand between back there, but the runoff, there's a drain right outside. There's a brand new runoff, storm drain right to the corner. So there's no water issues there either.
So that storm drain is in the road. It's on the edge of the road?
It is closer to the road.
Yeah, okay. Okay, I don't have any more questions. Anybody else? Nope. Okay.
Thank you.
All right. Without objection, I'll close the public hearing. Board motion and/or discussion?
I'll make a motion. I move that variance request for case VRB 2006 for the property located at 4523 West Fig Street be granted as depicted on the site plan presented at the public hearing for a reduction in the corner yard from 7 feet to 2 feet, reduction in the rear yard from 3 feet to 7 inches for accessory structure number 1, reduction in the east side yard from 3 feet to 8 inches for accessory structure number 2, with encroachment of eaves and gutters based upon the applicant presenting competent and substantial evidence in the record of this public hearing of unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 2780 of the city code, specifically that these were existing buildings when they purchased this property. They were built approximately in the 1980s, that there is equipment for their pool attached to these buildings, that they have investigated the possibility of moving them with more than one party and deemed that it's a more difficult move than would be considered reasonable.
I'll second that.
Okay, we have a motion for approval by Mr. Pastor and a second by Ms. Long.
If I may, Mr.
Yes.
Chairman, before a vote, they did testify that there were no gutters.
Right.
On either of the sheds, and the motion was for an encroachment for eaves and gutters. So I don't know if a further encroachment beyond what they requested is necessary.
Well, let's see, you got 8 inches and 7 inches for gutters. If they're, and I'm assuming that if there's a building permit involved in this or code violation, that entity would cause that to happen in that permitting process. If it was 0, I think you're right, but they're asking.
Well, we just heard testimony that there are no gutters.
Right.
So.
Okay. Would you want to amend that motion to include gutters, to be sure that if gutters are?
Did anyone ask about eaves?
No.
No. So.
My question is, if they get to the permitting and permitting requires them to put gutters in there, we've left room for them to have gutters.
Well,
So
but
I
they
would leave it
can't,
the way it
permitting
is.
would not cause the gutters to go across the property
Who
line.
would make them to put gutters on there then? That'd have to
If
be their
it's-
choice.
If it's a condition of a permit, that's how that would happen. But,
That's what I said.
but if adding those gutters went across the property line, that would be the issue.
Didn't you say there was 7 inches?
Well, but we didn't hear testimony if there were overhangs or eaves.
Okay.
The application was seeking the vesting of existing structures, so I don't understand that they're going through any type of permitting process.
Okay.
Just they were seeking to vest structures that were built
Well,
in
I was,
1988.
right,
was the
but I'm
testimony
saying
that was
if,
provided.
if there were modifications that required a permit,
Okay.
that entity would not allow, would not allow something physical to go across the property line. Right, right, okay. Thank you. Any other discussion? All right, all in favor say aye.
Aye.
Opposed, nay. You're been approved 5 to 1. Me. Next case is VRB 20-08.
Okay, Roberta Mead Curry, Planning, Design, and Development Coordination. I have been sworn. The address is 6230 Interbay Boulevard. The code section under review tonight is 27156. The applicant is seeking to reduce the side yard setbacks from 7 feet to 5 feet for all newly created lots proposed per formal decision 20-34, which was recently approved by Land Development, and I do have a copy of this for your record. I will give that to you soon. The applicant is seeking to create new lots and build new single-family homes. The variants for the lots are as follows due to how the drawings were depicted to us. So this is how we have written it up. Parcel A, applicant seeks to reduce the eastern side yard from 7 feet to 5 feet. Side yard along the western boundary will remain at 7 feet. Parcel B, applicant seeks to reduce the eastern and western side yards from 7 feet to 5 feet. Parcel C, same situation. Both side yards will be reduced from 7 feet to 5 feet. Parcel D, applicant seeks to reduce the western side yard from 7 feet to 5 feet. Side yard along the eastern boundary will remain at 7 feet. Applicant is seeking, has applied for a formal decision, and that is approved as of recently. We needed a copy. Again, some of the conditions outlined in the formal decision that they will go through subdivision, platting, and I think the applicant will go into that further this evening. Okay. What I have for your information is, again, the property went through a recent rezoning, and that information was included in your packet. The property was rezoned from RS 60 to RS 50. Legal description. And that was approved in October 2019. Natural Resources is here as well, and they have information that they're going to submit to the record. Property appraisers information. There was a house on the property which is being proposed to be demolished. Variance review map. Again, property consists of 2 parcels. Okay, the first parcel is here, with the second parcel outlined here. Interbay Boulevard, and again, basically surrounding property abutting. All property here is RS 50. View of the front piece of the property. Again, further to the front. In other words, to the far end of the front of the property. Looking east on Interbay. Looking west on Interbay. Site plan of parcel as it exists today. Okay. This would be parcel A. Parcel B. Again, Interbay is still located here. Parcel C. Parcel D. do have a condition that was received this morning that I will let you also have as part of your record. But again, I understand that condition may change this evening. Okay. So applicant will update this condition as well. I have nothing further.
Mr. Knox, welcome. I see you got dressed up again for us.
Absolutely. Brian Knox, Natural Resources. I have been sworn in. Natural Resources has found the proposed request inconsistent for the following reasons. The applicant has not submitted an accurate tree survey or a tree table. The submitted site plan did not include the required tree survey overlay. And per section 27-284 3.1, at least 50% of the trees must be retained on the parcel 1 acre or greater. This parcel is considered to be 1 acre or over an acre, and so by that right, 50% of the trees must be retained. The applicant has not demonstrated that this requirement will be met, and our concern is because of that, they could very well end up here again. And so Natural Resources would like to see that these conditions are met before this case is heard. I'm available if there's questions.
Any questions? No questions. Thank you. Applicant, please come forward, state your name, address, and if you've been sworn in.
Yes, sir. Just let me get to the updated letter that we've supplied to the city first. Steve Michelini, I have been sworn, and I am the representative for this project. I think that Brian's comments need to be qualified a little bit because we did submit a tree survey, and we also submitted a statement indicating that no more, we had no plans to remove 50% of the trees. The problem was that they didn't have sufficient time to review what we had submitted to them. But they did have the information. What we committed to was that prior to permitting, that we would update our tree survey, work with them on the field report, and here is a map that shows what we're proposing. It's also been get back to the microphone. That's also been updated. And I'd like to walk you through the site a little bit. Is everything showing on the screen now? We have an extremely irregular lot shape. As the staff pointed out, we rezoned this in October of 2019, and then we filed for this variance in June of 2019, and we're just now getting to you because of staff issues, staff concerns, how we identified these parcels, and the formal decision that we applied for and was approved. We just got the paperwork today indicating that it had been approved, although the staff indicated they had finished their review last week. What they're calling, and we also are calling lots A, B, C, and D. We're maintaining on the exterior 7 feet because that would be adjoining some other individual's property, and it would be potentially adversely affecting them. So we did the same thing on the other side, and we protected that with a 7-foot setback. The setbacks that we're asking for adjustments on are the interior touching lines for each of the homes that we are developing. And just to give you an idea, this lot is 155 feet on one side, 212 feet on the other side,
and then this is 212, this is 268 in depth, this is 325 in depth, and 382 in depth. That results in a 9,000 square foot lot here, an 11,000 square foot lot here, 14,000 square foot lot here, and 17,000 square feet. So respectively, this is more than 3 times the lot size requirement. This is more than 2 times. This is 2 times, and this is a little less than 2 times the lot size required for RS50. Because these lots are so narrow and so deep, we need relief on these interior side setbacks. And as I said, we were trying to protect the outside property owners. This is Circle C Ranch, which is not developed. It's a wide open recreation area and child care center. They just recently installed new water and sewer lines all up and down Inter Bay Boulevard. This has been designated as one of the principal infill and redevelopment areas for South Tampa. And part of this development is in response to MacDill Air Force Base begging for housing for its personnel. So we're responding to a lot of different pressures here. What we agreed to with staff, and I can read to you our letter of commitment if I didn't give you my last copy. Anyway, I know it by heart. Anyway,
would you like it back?
No, it's fine. I know what it is. We've agreed to an updated tree survey, and that will occur prior to platting. And then what we asked for was the ability to shift each of these housing footprints to minimize any impact that it might have on trees. So Natural Resources will have the ultimate decision to make. So if we slide this tree back, this house back, as long as we maintain the front and rear yard setbacks. So we're not asking to waive those, but we are asking to waive the interior side yard setbacks. And shifting these back and forward to position them correctly to save the trees is a commitment we made. We've also indicated to them that it was not even possible for us to remove more than 50% of the trees. There's only one grand tree, and it is way back here in this corner of this lot, and we're not going to come anywhere near that one. So if we have to come back to the Variance Review Board, that's something we'll do, but it's not anticipated that we would end up doing that. Let's see if there's anything else I left off. The building footprint may be moved rearwards to minimize the impact of trees. We'll have to meet all other applicable City of Tampa codes. And I think that's about it, except for the fact that it is a unique piece of property. It is triangular. It's very long and deep. It is consistent with the comp plan in terms of providing affordable housing for a demand that is clearly identified by MacDill Air Force Base. And they are calling frequently to this particular housing developer asking when their next product is coming online because there is such a high demand. In terms of justice being done, we could develop this parcel because it's residential 10 and it's more than an acre. You could develop 10 houses there. But we didn't think that was appropriate. You're looking at me puzzled. It res 10 and it's more than an acre. You have the ability to develop it. It would require a road network and some other things, including turnarounds for the fire department, which in our opinion would be overbuilding instead of bringing it back a little bit and requesting the 4 units that we have. Let's see, where was I going? Each of the lots are unique in terms of their length. I don't think I've seen a lot this narrow and this deep, over 300 feet deep, in quite a while. And that also provides a lot of open and green space. All of the accesses will be off of Inter Bay Boulevard. But what we could have done was to shift houses so that they were stacked and then put a roadway in, which You know, it just didn't make any sense. So anyway, we've made these commitments. We want to make that part of the record. That the condition is that we be able to move the footprint backward to preserve any impact or adverse impact on trees, and maintain those same property lines along the sides. This is what the raw parcel looked like without those lines. And you can see this backs up to another single-family residential area. And as I said, this is Circle C Ranch on this side. So we believe that we've met the intent of the code and the intent of the comprehensive plan. I don't think it was designed to deny the ability to develop these lots in a reasonable manner. And it's not overbuilding because it's surrounded by RS-50 properties that, you know, basically have the same development criteria that we're proposing here. I'll be happy to answer any questions. I mean, we are not adversely impacting any off-site properties, and we've taken measures to preserve the side yard setbacks where it does abut an additional property owner. So I respectfully request your approval. I'll be happy to answer any questions.
All right, thank you, Mr. Michelini. Is there anyone in the audience that would like to speak either on this application or against it? Okay, seeing none. Board?
I have a question for
Mr. Feldman.
For legal. I appreciate the applicant's position that they're willing to move and shift these houses depending on what natural resources does. How does that impact our approval language that is tied to the site plan?
So the applicant has provided the board with the proposed condition that would address that ability to shift. Typically, when the variance review board approves a variance, it's limited to the site plan, and there's not that ability to move it around. This is you know, a novel approach to allow this to move forward. He just recently received the formal determination letter allowing his client to create the 4 individual lots. That was part of the reason why this application was filed previously. It was not heard until now, because until recently we didn't have the 4 lots to be recognized as legal conforming lots of record.
But I guess my question is...
Yeah, I'm thinking through that. I mean,
I see that he's got realistically the issue is the setback separation between lots, right? So it's 7 to 5. Mm-hmm. So he's got it set such that you can basically slide these houses up and down, and as long as they meet that setback as drawn on this plan, that would work. I just want to make sure, it seems logical, it seems like it could work. I just want to make sure that from your standpoint, we're okay with approving something that would be almost a fluid site plan with these blocks sliding around on there.
And it would be. It's understood, and it's been submitted by the applicant that if this variance is approved for each of the 4 lots, that it would not trigger the need for any other variances. And he's not requesting any other variances. One item that was discussed was whether or not, because of the location of the proposed homes and the trees, would you be triggering the need for a variance from that 50% threshold that you're required to maintain on any property that's greater than an acre? They've committed to not needing that waiver. The other alternative is to, if the board is inclined to grant the variance because he's met the hardship criteria, to not include this condition that would allow that flexibility at the time of permitting. And in the event that they need any other variances, they would have to come back before you. So I think they're trying to avoid that situation in the event that the location of the proposed homes would impact more than 50% of the trees. I'm comfortable with the approach here, as long as this condition is read into the record and natural resources and staff understand how it would be applied at permitting.
Well, and that's my next question, is to natural resources on that issue. Mr. Knox? I heard your concern. I heard your concerns at the start of this presentation, and it sounded like what you were saying is you really didn't have enough information at this time, and you were concerned that because of that lack of information, there could be other triggers. Did the applicant's conditions, as they've expressed them, satisfy your concerns? Is that something that you're okay with?
If the applicant is willing to move forward under the condition of understanding that they would have to show up for another variance, you're saying no variance.
Let me address that real quick. This is language that we discussed with Kathy Beck over the last several days, and I developed it, sent it to her, talked to her again today, and there was no objection to that language going forward, as long as we understand that there's a burden on us, that if it, in the future we know, or the staff says, hey, look, you need another variance, then we'll have to notice for that and come back in. We are confident that we don't need any more variances, and we are also very comfortable in moving forward as long as we can move the houses back and forth, not trigger a front yard setback or rear yard setback, which we would also have to come back to you for. We think there's enough of an envelope there to satisfy natural resources and maintain those front and rear yard setbacks. So we're comfortable moving forward at our risk and in our own jeopardy. And like I said, we sat down, and as I said, as recently as this afternoon, and talked to Kathy about it. I gave them copies of what the proposed language was 2 days ago, and so it's been a sort of a solution in motion, and trying to figure out how, because apparently our tree survey doesn't reflect all the trees, and that's why we said we're going to come back with a revised tree survey, so we can more carefully plan exactly where that positioning of the homes are. It won't affect the side yard setbacks, but it will affect potentially the rear, but not to the point where we would need another variance for that. So we were trying to cross all the T's and dot all the I's in a unique manner, and also satisfy natural resources that we weren't going to adversely impact a significant number of trees.
Yeah, and I see that, and I think it's a good approach to trying to address these issues. The only thing I wanted to check with you on was there's no language in here about the when I say here, I mean your February 11th condition language.
I'll be happy to add it.
Well, I don't know that you need to, because I just want to make sure we've got it on the record. It sounded like it was, but the 50% of the tree issue is, you're saying you will not exceed that issue, and you will work with natural resources to maintain that minimum level of trees.
Yes, sir, that's correct, and we commit to not triggering that, and as I said, the burden is upon us, and if we do trigger that, unfortunately, we'll be back in front of you, but I don't think we have enough room. These lots are very, very deep, and that gives us a lot of leeway on how to position the homes.
Thank you.
Thank you.
Anybody else?
Yeah, how wide are each of these lots?
50 feet.
Then that's what you're supposed to have, so I'm not sure why you need these side setbacks.
Well, the house, the footprints of these homes are 35 feet wide.
Is there a reason you couldn't make them narrower?
Only livability and the ability of having a product that's going to fit on these lots, and also have, we have the interior sides with the utilities and things like that. I mean, I guess it's technically possible.
Yeah.
But the product itself, when you start building on lots like these that are very, very expensive, it's very difficult to get a livable space that's going to work. These are about 2,500 square foot homes, and that's the garage and other things. So it's a very narrow product.
I guess I'm just not seeing the hardship here. because if you have all this space, you could make it more narrow. I'm
Let me clarify, the 50 feet is diagonal. So the lot is not 55, it's
Yeah,
not
no-
50
no,
feet
it's-
wide, it's 45 feet wide,
Yeah, it's-
35 plus 10.
At the front, the front measurement is 50 feet, but these are all trapezoidal lots, so they're skewed, they're not exact.
okay. My understanding is cost is not a hardship, though.
You asked me a question, I was just, I wasn't relying on that as the reason.
Okay.
I'm just saying that your actual measurement, as one of the members has pointed out, is not really 50 feet.
Mm-hmm.
Any other questions? I have one for legal, I think. I get the concept of the sliding front and back that's being proposed. Are they bound by the size of the rectangle they're showing, which is about 2,000 square feet?
I would submit that they would be. That is what is depicted on the site plan. That is their proposed footprint of the building. They would be limited to that footprint.
Okay. Is there a certain amount that they might be able to increase it at staff approval level?
At this point, the application before you is what you get to vote on
Right.
or down, whether or
I'm
not
just
they
trying
meet
to
the hardship
understand.
criteria.
Yeah, I'm just trying to understand the logic here, because we're being asked to consider this as a single parcel when it comes to trees, but we're being asked to consider it as 4 parcels when it comes to setbacks, and the parcels don't even exist, because they don't exist until they're platted, right? Is that a legal
And we had
correct?
that conversation with Mr. Michelini a couple of months ago and suggested that he go through the plating process. He explained the difficulty that they would have to do that and the cost involved, not knowing how they could ultimately be developed. So he chose to go through the request for a formal determination letter, which he received from Mr. Cotton. It was dated February 3rd, recognizing the ability to establish these 4 lots as they meet the minimum lot requirements and width requirements for the RS50 zoning district. So that they've chosen this path of rezoning to RS50, requesting a formal determination letter to recognize these 4 lots, and appear before the VRB seeking these variances. And this is a fluid concept, and we're trying to accommodate being able to move this forward.
Right.
If the board finds that Mr. Michelini has met the hardship criteria for each of the 4 lots. And if you feel that the hardship has been met with the condition that is being proposed, it would limit the approval to the depth or length of the proposed structure. That would not be moved, because typically when you're approving a variance, it's as depicted on the site plan. You don't get to move structures around. You don't get to increase the extent of the variance being approved. So I would submit to the board that if they were to lengthen the home, you are increasing and going beyond the variance that would have otherwise been approved. The only ability is to move that home further back from the front yard setback in order to preserve whatever trees are determined to be appropriate for preservation by natural resources.
Okay, and his site plan, even though it's not real clear when I blow it up, but that dimension in question appears to be 54 feet. Is that correct, Mr. Michelini? The 54-foot dimension that's shown on each box, each footprint box?
Hold on a second.
I'm talking about the length, the depth of the structure.
Right, we weren't anticipating increasing the footprint. We were only anticipating sliding.
Sliding, right.
The
right.
footprint that is shown.
Okay, I just wanted to be clear
Yeah,
with everybody that
we
you're
weren't
asking us
trying-
to approve the sliding concept based on the size of the box that's been drawn on the site plan.
Yes, sir, that's correct.
Okay. All right, because you can't
No.
come in and stretch that box 10 or 12 or 20 feet.
No, this wasn't that we were trying to squeeze and push the envelope. The envelope that was shown is what we were proposing, and that should remain the same, only being able to move it backward,
Okay.
to the rear.
Okay. All right, for legal, my last question is, and we've danced all around it, but you just said that this is new and unique and different to a process of development. Wouldn't a PD normally handle this? And I guess the applicant didn't want to go through a PD. Is that what
I would refer that question to the applicant.
Okay, applicant. How come you didn't do a PD on this?
You know, after what we've gone through, I wish we had. This has been a very long process, and it started off under a different concept, and I don't think that that was fully thought through. But I can guarantee you that if there is a next time, it'll go through a PD process.
Okay.
And
well, I'm not trying to throw somebody under the bus.
It was an oversight, and you know, quite honestly, the staff has been working with us diligently to try to figure out and sort it out. And that's why we have some unique provisions here on this variance. And I hate to bring that to you, but it required a lot of thinking on a lot of people's parts to come back with something that might work.
Okay. And the only reason I bring up the whole PD concept is legal is that if these aren't legal lots yet because they're not platted, I mean, to me, this is clearly a self-created hardship on a larger piece of property being subdivided, but it hasn't been subdivided yet legally. So I'm hearing you say it's okay to make a decision on this even though we don't have legal lots yet. Is that correct?
There is a formal determination letter recognizing the 4 lots.
Okay, that recognizes them as legal to-be lots, right? What if the applicant tomorrow decides he doesn't want to plat this the way he's drawn it up, but he's gotten these setback? You're saying that all goes out the window and they got to start from scratch.
So with the letter that was issued by Eric Cotton, it recognizes the 4 parcels as described by Mr. McElhaney. It recognizes that they have a minimum of 50 feet in width. It identifies the total square footage of each one, and I believe at the end there is a requirement that they go through the plating process. If you could confirm that for me, Mr. McElhaney?
Yes, that's accurate. There's also a legal description that's attached to each one of these lots.
Mm-hmm.
So it's not, the formal decision is linked to, you know, the legal description. So it's not, we're not trying to switch things around here. It's just a matter of how, in terms of the timeline, how you go through each of the remaining processes. Okay. But we will have to jump through those hoops at plating and again at permitting. And there's no attempt here to kind of trick the board into.
No, I wasn't implying that because they are so large. There's no issue about that, square footage wise. I was just trying to get my head around the whole concept that we're being asked to approve something that doesn't exist on a site plan that does exist with legal descriptions that exist.
We've been working through those issues.
Okay.
What I will say on the 4th page of Mr. Cotton's letter, it does say the property must comply with the City of Tampa subdivision regulations.
Okay.
If Mr. McElhaney's client were to come back and divide this further so that we're not looking at 4 lots, we're looking at 5 or more, then these variances would go away because these variances would be limited to these 4 lots as shown on the site plan.
As described. And if they decided, okay, forget it, we'll do 3 lots, then they didn't have to come here tonight anyway in that case. So, okay.
Understood.
All right. Anybody else? Okay. Yeah, 5 minutes for rebuttal.
I think we've discussed it enough.
Okay.
Unless you have more questions for me. Like I said, you asked one question about, in one respect, it's a 1-acre parcel, and in others, it's 4 individual parcels. We've been back and forth on that issue for weeks and weeks, and so finally we just said, you know, fine, we'll do it in the most economical way in agreeing with the staff. In some respects, it's a 1-acre lot, and in other respects, it's not. But these are legally created now, and they have legal descriptions that attach to them. And our intent is to develop 4 single-family homes. That concludes my presentation and rebuttal.
Okay, without objection, I'm going to move to, I'm going to close the public hearing. Board, is there a motion for anything or discussion?
I'd like to speak first because I think have overcomplicated this significantly. The 4 lots that exist today are the most irregular lots I've ever seen. If you look at them as one 1-acre lot, it is also highly irregular. What they're proposing to do is to split it into 4 RS50s, which dictates the 50 feet, but the 50 feet is on a slant because it's irregular. So in effect, it's not 50 feet, it's roughly 45. To go down the road that this is self-created is a big stretch. What we've got now are little pie-shaped and slivered-sized lots that are useless. So you can make it one big lot, they'd still be here with an irregular lot, or you can make it RS50 and try and get 4 houses. And trying to comply with RS50 dictates this slanted front yard and therefore the width issue to get a standard 35-foot wide house, et cetera, so on and so forth. You could do it as a PD, it'll look similar to this. I think that's all irrelevant, really. The question of the condition to slide it and all that, certainly is something we need to discuss. I have no issue with it, makes total sense. If they're not encroaching in the front or the rear, then what do we care? It's really the issue of 5-foot versus a 7-foot side yard. The people that buy these homes will know that when they buy it. The neighbors that neighbor these properties are gonna have their 7 feet, so they're not encroached. So I don't think it's a big issue. If anybody else wants to talk about it, now's the time. Otherwise, I'll make a motion with a condition.
Yeah, I'm just, I don't know why that the people who are already there get 7 feet and the people who are buying get 5. I'm not okay with that.
That's their choice. They're buying it.
I know, but I think that it's a really deep lot. They could make it work if they really wanted to.
Well, that's an interesting point. The reason I'm okay with it is because the longer they make these houses, the more impact they have on the trees that are there. And it seems to me like keeping them in this compact shape is less impactful to the trees, even though they're cutting somewhat into that side setback. But and that was the point that made me comfortable with it as well, was you're not hitting the neighbors that are there. You're only hitting the people that are buying in, and you can buy into a 0 lot line townhome. You know, you can buy into those things all day long. They can exist as long as you know what you're getting, and you're not you're not pushing up against some neighbor that was there. To me, that's okay. It's almost like you're getting a subdivision and you're saying, okay, this is the way all these houses are going to be. People are going to have the opportunity to buy or not buy them. And if they don't want to buy them, they're just going to sit there and they're not going to sell.
Yeah, what do we care?
But I mean, I that's the way I look at it. I think you made a good point. I just see it more impactful the other way.
You could build a 4-unit townhome. They'd all be connected. You'd be knocking on your neighbor's wall. That's your choice.
So I disagree that this is not a self-created hardship. I think that it is certainly a self-created hardship, but I'm still inclined to vote in favor of it because I think that all of the other criteria here have been met and, you know, outweigh on balance, you know, the fact that the applicant is the one who's also subdividing these.
I'll just make a brief statement. My only reservation was answered because if we approve this, they're legally bound by the legal descriptions. And I do have a little bit of concern about the self-created part of what you said. I don't disagree with that, but the same condition might occur if they went a different zoning route. But at the same time, they'd be answering all these other questions in one fell swoop. But it's a very time-consuming and costly method, so I kind of think this is unique. Obviously, the property is not unique, in my opinion. The single parcel is not unique because of its size, 1-acre size.
Which is unique. Which is totally unique.
Yeah, it's unique in the area. You're right about that. So, you know, they do literally meet the minimum standards for RS50 with the way they're configured. So I don't, you know, because of that and the fact they're bound by legal description, I just wanted everybody to understand that they were in fact being bound by the square footage of each footprint, which only gives them the flexibility of sliding these forwards and backwards. So if that's what they want, I'm inclined to support it. All right, somebody like to make a motion?
Move that variance request for case VRB 2008, located at 6230 Interbay Boulevard, as depicted on the site plan presented at the public hearing, for reduction in the side yard from 7 feet to 5 feet for all newly created lots, of which there are 4 proposed lots, with encroachment of eaves and gutters, with the condition that the footprint of buildings proposed are tied to the site plan. However, the location of those footprints may move so as they do not encroach upon the front or rear yard setbacks or any further into the side yard setbacks than what is being proposed with this variance. And that they will stay below 50% of reduction in trees as worked out with natural resources. That said, variance as condition be granted based upon the applicant presenting competent substantial evidence in the record of this public hearing of a necessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 2780 of the city code, specifically that is currently 4 highly irregular shaped lots or 1 irregular shaped lot, depending on how you look at it. They're proposing to create 4 RS50 lots, which are still irregularly shaped in length and in the angle of their front yard, which creates a narrower than 50-foot lot, and is asking for relief in the side yard setback only to the properties internal to the development.
I'll second.
All right, we have a motion for approval by Mr. Pester, seconded by Mr. Feldman. Ms. Long, do you have a comment? Okay.
You're allowed to move those building structures up and down the lot based on recommendations from natural resources, not just because they're in the mood to do it. Did we add that in there?
I don't know that that's necessary.
Okay. Do it anyway.
Yeah, I mean, I don't see the benefit in that.
If I may, that was the suggested language by Mr. Michelini, was that it would be with the advice and consent of the City of Tampa Natural Resources Department at permitting.
I accept that proposed modification.
Okay, thank you.
All right, we have an amended motion and a second. All in favor say aye.
Aye.
Any opposed?
Nay.
You've been approved 5-1.
Thank you very much, Board. I appreciate your understanding and reviewing this unique solution to this problem, and also like to thank the staff for working with us. It's been a long path, so thank you very much.
All right, we're moving right along.
Chugging right along.
Next case is VRB 20-11.
Roberta Mead Curry, Planning, Development, and Design Coordination. I have been sworn. The address is 3514 West Barcelona Avenue. The code section in question tonight is 27156. The applicant is seeking to reduce the east side yard setback from 7 feet to 4'10". Applicant is seeking to construct a second-story, 2-story addition atop the existing primary structure. The property is zoned RS50, and the Hillsborough County Property Appraiser information is included in your information packet. There is also a tree consultation permit, TRE 16-044-0435, a tree removal and pruning permit included for your reference. Natural Resources is here to add some additional comments, and their report is included in your packet as well. Property appraiser's information. Variance map. Property is located here. This is South Himes Avenue. Barcelona is here. Surrounding properties are RS50. We have some RM16 to the north and RS100. Front of property. Looking east. Looking west, down Barcelona. Site plan, the site plan here is the site plan, existing site plan, existing primary structure, existing accessory structure, pool, and this is just showing the roof and proposed 2-story addition, which is following the same lines of the existing house with a little bit more punched out to the front here. I have nothing further to add to the record.
Okay, Mr. Knox?
Brian Knox, Natural Resources. The applicant is requesting a side yard setback from on the east side from 7 feet to 4 feet 10 inches to add a second story to the existing home. On the west side, there is a 48-inch off-site grand tree with the average canopy spread of 60 feet, and it was rated as D9. And so the applicant is proposing to build a 2-story addition approximately 20 feet from that tree. The proposed 2-story addition required 2 large diameter limbs to be removed. Natural Resources went out to the site, evaluated those limbs, and made the determination that it would be, in a personal opinion, better to remove the tree than to try to make those cuts. Given that that was the issue, we met out with the applicant again to look at the tree, but by the time we got there a second time, the limbs had already been removed. And so those limbs were removed. They were proposed to be removed under HB 1159. The company that they hired misinterpreted the rule that claimed the right to prune the grand tree without a permit. The company was not a certified company. They weren't certified by the International Society of Arboriculture, which means they were not in compliance with the rule of HB 1159. And by that, the applicant was subjected to a triple permit fee for their site for pruning a tree without a permit. Just to give you some reference for that, for the tree on the west side, this is the grand tree that's 48 inches located off-site. There are several limbs that are still on the tree that are completely dead that the company chose not to remove. Here are some other pictures of the tree. Once again, there's the limb that goes out into the right-of-way that was not removed. Here's a better picture of it right here, running along here. And these are the cuts that were made afterwards. We only have close-up pictures, so I apologize about that. But
could you turn that?
There you go.
Thank you.
So it was a cut made here, here, and here. There was an additional limb that was left that may still impact the 2-story structure. We're not certain of that, but for the most part, the 2 limbs that we had the most concern about were already removed. Natural Resources is available if there's any additional questions.
Just for clarification, I don't know if everybody on the board knows what HB 1159 is all about, but the tree was on the neighbor's property.
That's correct.
So the neighbor gave permission, or the neighbor did the cutting?
I am under the understanding that the neighbor gave the applicant permission to make the cuts to the tree.
Under what they thought they qualified under 1159?
That's correct.
Okay, but because they didn't use a certified arborist, they're not in compliance with 1159?
That's also correct. And
okay.
Also I have...
but is that the applicant's problem, or is that the neighbor's problem?
If I may, I would suggest that that whole discussion is really not relevant.
Well, that's what I was getting at.
Tonight's meeting, you know, with all due respect, however they got to this point in time, if there was a violation of the code, that will be addressed separately and outside of tonight's meeting.
Okay. All right. Any other questions? Yeah. Go ahead, Mr. Fell.
So because there's still a limb there, it does impact what we do if we need to go, if we're going to go vertical. Can you just tell us, I didn't see it in your report, what kind of tree?
It's a laurel oak.
Okay. Do you, and D9,
D9.
not the greatest condition,
Right.
Do you know how old it is?
It's a 48-inch tree, so roughly it's about 40 years old.
Okay.
So,
Thank you.
Also, I do have the letter from the arborist that I'd like to submit to the record.
Again, I would submit that this entire discussion is out of order and not relevant to tonight's meeting.
Okay, all right. We get it.
I mean, to the extent there's still a limb there, it is relevant, right? If we're gonna go up and it could impact that limb, there's still relevance to that limb. I don't care about the gone limbs, that's not relevant. I agree.
Called sunk costs.
I don't, none of that matters, she's right, none of that, in my
I
opinion,
agree.
she's right, none of that
Ancient
matters,
history,
except
done.
for there's still an existing limb there,
Can't change it.
right, maybe?
I agree.
When Mr. Knox testified earlier, he said the concern was about primarily with the two limbs that have been removed.
Understood. Out of mind.
Okay. All right, applicant, please come forward and state your name, address, and if you've been sworn in.
Guess, is the microphone over here?
Yeah, you may.
It'll work if you just talk regularly.
All right. I'm Matthew Algio, 3514 West Barcelona. I have been sworn in. Thanks for having me here today. I think to further what Ms. Mead mentioned earlier regarding what I'm proposing, I wanted to kind of describe the location of the house on the parcel. This is uploaded on the Excel website already, but the house was constructed in 1947. I purchased the house in 2018. The house is set towards the east to allow for a driveway on the west side of the property. That's how it was originally constructed. I'm simply requesting to build on the existing walls that are there. So I'm proposing to maintain the east yard setback. I've sent the letters to all the neighbors and discussed with neighbors on both sides, east and west, specifically, and walked them through my intent and my plans. The elevation is the current elevation on the top right-hand side of this document, and then the front elevation from Barcelona Street is on the bottom, the proposed future addition on the second floor. Regarding the oak, because it has been said, my neighbor was consulted, and the same company that's been maintaining that tree for years for my neighbor was hired to continue the maintenance of that tree. As far as any other hardships, it would just increase the cost of the renovation. I purchased the property and trying to create additional bedrooms upstairs. It's a small home. It has 2 bedrooms under roof currently. As my family grows, the additional bedrooms are going to be necessary to make it a suitable home. And it would add quite a bit of cost to move foundations and not simply keep the existing walls where they are. The variance does not harm the health, safety, or welfare of others. And all other setbacks are met within the property on the front, back, and the west side. That's all I have.
Okay. Is there anyone in the audience that would like to speak on this application, either for or against? Okay, seeing none. Board, do you have any questions for the applicant and or staff? Okay.
What is the total height of the proposed finished building? I couldn't read it there.
Yeah, it's 30. It's below 35 feet.
Okay, well that was my question.
It's 32 and some change.
And this is just for my own curiosity. I think it could be applicable though. Your architect has addressed the additional structure needed to support another story And whatever he's doing to address that, it's gonna stay inside the walls that you have today?
It's a she.
It says Mike Pilara, architect.
He works for her. Her stamp is, she's back there, but anyway.
So that was not gender bias, it was
He's the
documented.
agent, but she's the architect. She's got the stamp on the drawing, but yeah, we have structural drawings to support the second story addition.
And it's contained within the walls, the footprint that you have today?
Yes, sir.
Okay.
Any other questions, board?
Was your house, the way it sits now, legally non-conforming, or was it, do you need to get a variance to vest it? I guess that's what I'm asking. Because it's only 4 point, what'd you say, 1?
It's 4.9 feet.
10 inches away from the property line, which is.
4.9, which works out to about 410 and a quarter, but.
Okay.
I think anything less than 6 is, you can't do an administrative approval on a side yard setback, so here I am.
I understand that, but I guess, in the process, are you vesting the original house?
I'm not sure what that, can somebody help me understand that question?
Okay.
The answer is, yeah, you would be.
That's what I'm thinking.
Yeah, you would have to, because
That's what
they
I'm
become one and the same, so.
Mm-hmm, okay. That's it.
Yeah, just to clarify, we did hear testimony that you're adding to the front, I guess, a porch. And the site plan does say 20 feet to the proposed, so you're maintaining the minimum front yard setback.
Yes, sir, and it
Okay.
is a porch.
Okay. Any other questions? All right, you have 5 minutes for a rebuttal, if you need it.
I'll Google vesting of my property, but I don't need any rebuttal. I might need some coffee, though.
Okay, does that conclude everything?
Yes, sir.
All right. I will close the public hearing and ask the board for a motion, followed by discussion.
Make a motion. Move that variance request for case VRB 2011 for the property located at 3514 West Barcelona Avenue be granted as depicted on the site plan presented at the public hearing for a reduction in the east side yard setback from 7 feet to 4 feet 10 inches with encroachment of eaves and gutters based upon the applicant presenting competent substantial evidence in the record and at this public hearing of a necessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 2780 of the city code, specifically that there's an existing structure he would like to expand vertically. The walls that exist today will remain. The encroachment being requested is the encroachment today, except for the additional vertical encroachment. He testified that both neighbors are in agreement and we heard no opposition. The practical difficulty would be moving the home to meet this setback is not practical.
Okay, we have a motion for approval by Mr. Pastor. Is there a second?
I'll second.
Okay, we have a second by Ms. Long. Any discussion? All in favor say aye.
Aye.
Aye. Any opposed? You've been approved, 6-0. I'm gonna move to take a 10-minute break. Make it 5, okay. 7.5. 7.5.
Okay, Roberta Mead Curry, Planning, Design, and Development Coordination. I have been sworn. The address is 2417 Thrace Street. The code section under review this evening is 27156. The applicant is seeking to reduce the rear yard setback from 20 feet to 2 feet due to an irregular shaped lot. The applicant is seeking to construct a 2-story single-family residence. Applicant received a formal decision regarding the parcel. And I have that formal decision here for you, and I got the number wrong. It's formal decision FDN 19-104, which was issued in October 2nd, 2019. The property is zoned RS50, and the Hillsborough County Property Appraiser's information is included for your reference. Right-of-way has found it consistent, transportation has found it consistent with conditions, and zoning has found it inconsistent. Formal decision here. Not seeing any conditions on the formal decision. Property appraiser's information. Again, it's showing an existing structure, and that existing structure will be torn down to build a new structure. Variance map. This is South Bermuda Boulevard here, water. Thrace is here, parcel is here. These surrounding properties are RS50. Front of structure. Again, this is going to go away. So it'll be basically a blank slate. Looking east. Looking west. This is a survey of the property. Again, showing the footprint of the proposed house meeting RS50 setbacks, 20 feet, 7 on the sides. It still would meet technically here, 20 feet. They're showing 35. This is the issue. And this is where they're asking for the reduction of the 2 feet. There is an objection letter on file from a Carmen Munoz. And this is the owner of this parcel here. And that objection was included in your packet. I have no further information to add to the record.
Just for clarity, since we have the letter of objection, can you show us the aerial again? And do you know where that neighbor's property, the boundaries are? If you zoom in, maybe. I don't know if it's. Do they own? It almost looks like. Well, it could be either house. We don't. Which house does that little out
This
parcel?
is the property. Oh boy, with my pen.
Yeah.
This is the property in question. Okay, in red, but the
Right.
little piece is right here.
Yeah, but
That's
what is
the
that?
objection.
Does that belong to the neighbor to the side or the neighbor to the rear? That little piece.
The neighbor to the rear, which is a totally different. I'm not sure I'm understanding your question.
Well, I'm just curious, and maybe the applicant will clarify it. I'm just trying to understand. She's objecting, and I want to know who she is. Is it the neighbor to the right or
Yes.
the neighbor to the
This is
south?
the little piece that you're in question, and this
Okay.
is the property card for that, and this is the owner who's objecting.
So she only has that little piece.
Correct.
Well, or maybe not. I mean, she could have the parcel next door.
She does not. We
She
checked.
does not. Okay. All right. Thank you. Any other questions for staff? All right, applicant, please come forward, state your name, address, and if you've been sworn in.
My name is Michael Fernandez. I'm actually the agent for the person who currently owns the property, Sherry Swanner, as well as Diana Del Judas, which is here with us today, who's interested in purchasing the property for herself to build a home and move her family in. What happened, from my understanding, is that back in before 1955, family owned it. An aunt wanted to live there, so they subdivided this little square and put a small little apartment or something for her on there before zoning, I guess, came in with all the regulations. And that's how it got divided. But since 1955 till current date, it's been owned by different people. So therefore, it is a, I guess, conforming lot. I'm not sure if that's the right terminology or not. But I went with Eric Cotton, and he told me that everything is fine with it, and I can move forward with the variance. Because different owners have owned that lot, and it was never owned by the same person, they should have then joined the properties together, but because it's owned by different people, it was never joined, which brought us here today. Diana Del Judas is interested in purchasing the property and has already made an agreement with Sherry Swanner to sell the property. Carmen Munoz owns 4 other pieces of property in this neighborhood within a 5-mile radius. She is the owner of multiple properties. I'm not sure how she acquired this property. She told me that she bought it for $100, or her aunt gave it to her. She told me 2 different stories in 2 different conversations, and that she'll never release it because it was a family piece of property. I've heard from other people that it's not true, that she did buy it for $100, and she's holding on to it, hoping to get the rest of it from Sherry Swanner. There's a few issues with it, which I'll get into in just a little bit. Diana, she is a single mom, 2 children, one in college, one getting ready to go to college. She wants to build a home to be able to have her family there. The reason why she wants to move there is because my parents live 2 blocks away from there. They're really elderly, and I want to move there also to go ahead. So we're going to do it together to be close to my parents to help them in their elder years and do the day-to-day operations of taking care of them, the house, taking them places, go places, all that stuff. So when we were looking, we first were looking in South Tampa, where we grew up. We both went to Plant High School, and everything is way too expensive over there. And in the West Tampa area, way too expensive. So we have found this property, which has a lot of problems, which I'll get into, which is someplace that is convenient to take care of our parents, as well as we're in the area that we want to be. We were going to, which you stated, we want to build a single-family home on there. We know that because of the flood zone in that area, that we have to elevate the home and all that other stuff. We've done a lot of research on that. So we have something in mind that we want. We don't have a site plan or anything yet, because we don't know if we can acquire the property or build on it because of this small cutout in the back. The small cutout is giving us only, right now, currently, a 20-foot footprint to build on, which is not even a double-wide trailer length. So therefore, we're wanting to see if we could put something that's going to be at least 40 feet deep by 35 wide to keep all the setbacks 20/20 on the extended part. Our hope is that if we get the variance, I've already offered Carmen money, and she turned me down and said that she wants to keep it and she wants to get the rest of the property. And I said, well, Sherry will sell it to you for 60 grand if you want it, and she's not willing to pay anything for it. So I said, okay, well, I'll give you 5,000 for that little square. She said no. So we've gone back and forth. I tried to rectify this before coming here today, and it just didn't work out. Right now, with that setback from her square forward, gives us 20 feet to build. Obviously, we hope that if we get granted the variance to get 2 feet from her property, that eventually she'll concede and sell us that piece of property. Then we both can be the owner and move forward with completing that lot back into one lot like it was prior to 1955 or 40 or whenever it was divided back in the day. And then we can have a full lot. If not, we're both fine with her keeping that property. We've been told that that property doesn't even get charged taxes because there's not enough square footage on that land. She hasn't paid a lick of taxes, property taxes, because it's not even big enough for, I guess, the city to charge taxes. That's, if you look at the tax records, I know this guy's got his face, but if you look at the tax records, she hasn't paid taxes since she's owned the property. There's not enough millage, from what I'm told, not enough square footage to charge a millage rate on it. So therefore, nothing can be done on it, nothing can be built on it when she saw us starting the process of trying to acquire this property and begin to look into knocking down the house and building on it. She put up a fence to designate her square property there. So basically, we're just looking to build a single-family home and live on it. If she wants to work a deal with us later on for us to purchase that property, we're more than happy to buy it. If not, we're more than happy with her keeping that back little piece there and us having the rest of the property if you guys grant us a variance. The current owner, Sherry Swanner, is not healthy at this point. The reason why we're here today and it's taken so long to get here is because when I did want to sign the paperwork necessary to get a variance, she was in the hospital for a month. We couldn't get the papers signed up and notarized. When she got out of the hospital, obviously we got that done, and now we're here today. She got the property from her significant other years ago. He passed, I'm not sure what date he passed away, but probably about 5 or 7 years ago, 10 years ago, whatever it was, but he quitclaim deeded the property to her. She acquired it, I guess, 5 to 3 years ago in a quitclaim deed. She was thinking that she was going to get some kind of an asset. Instead, she got a lot of problems. The problems that came along with that property are such that code enforcement fines, let me look at my paperwork real quick, $18,100 for one code enforcement fine, another one for $8,750, $55 code enforcement fines. I contacted the city of Tampa attorneys, and I got an estoppel letter with a settlement agreement of $3,020 that Diane and I will both pay. If you guys grant us the variance, we will pay it. If not, we're running from the property. The code enforcement has also now condemned the home. And because the house has been vacant for 2 years, animals were in there, and I hate to say it, but drug addicts were in there and stuff like that. So what I did was, as the agent and permission with the owner, Sherry Swanner, I went in there and I cleaned up all the property, cut the grass, took up there was bottles and sinks and tires and couches and everything. I got pictures if you guys want to see it. And I cleaned it all up, cut all the grass, not even knowing if we were going to own the property or not. Got lawyers involved to make sure that we were going to be safe in all of this. Long story short, so that way there would be no more code enforcements enforced or added to already, so we can minimize our cost in all of this. But anyway, we've negotiated down to $3,000 on that. Code enforcement, what's his name? Wallace Nelson. I've been in close contact with him. I told him that if I get the variance that we will knock down the house immediately and go through the process of demolition to clear the property and get it all cleaned up. In addition to that, there are other issues. Sherry also has some liens against hers personally, so we're going to have to wait to complete the sale and to move forward with us and permitting and stuff like that and site plans until after October, until some legal stuff with her personally is cleared up, just in case that gets attached to the property prior to that being cleared up in October. Let's see here. Property taxes are currently due. Sherry doesn't have the money. Diane and I also agreed, if we get the variance, that we will pay the property taxes immediately as soon as we know we get granted the variance to clear up the property taxes that are due this year. There's nothing in the rears that are owed. She did pay them last year. From my understanding, to talking through several people as well as neighbors, Carmen Munoz, who does own that little square in the back, there's nothing she can do with the property, but she did take the prior owner who quitclaim deeded to Sherry, which was Doug Adkins, to court to try to get that property from him years ago, and it was thrown out. It was a frivolous case that she was trying to acquire that property. This is all hearsay, though. I wasn't there. This is what I've been told. So if Diana is granted the variance and I am brought in along with it as her partner, we plan on building a single-family home with a bonus room. The structure that we plan on building is about 40 feet deep, 35 wide, to keep all of the setbacks in line. The only thing that we're hoping is that if we get granted the setback, then that we can also acquire that second piece of property. Then I guess you have to rezone it. I'm not sure what has to be done, but make it all back one again, and that's our hopes. So I'm open at this point to any questions, if you guys have any questions, or I can show you documents and pictures if you like.
Does that complete your presentation?
Yes, sir.
All right. Is there anyone in the audience that would like to speak on this application, either for or against? All right, seeing none. Board, do you have any questions for the applicant or staff?
I guess I'm not clear with the portion that's not his, is there anything on that?
Yeah, I'm sorry, am I supposed to answer?
Yeah.
Yeah,
Oh,
yeah.
The property that Sherry Swanner owns that we're interested in purchasing, I don't know if I guess you could see it in the plot survey or it's a 50 by 95 and then 29 across the back and 33 towards the front is a little square that leaves us 20 all the way to the 95 side, and then it cuts us down to, I think it's 65 from our property line to Carmen Munoz's property. So it's kind of we call it a postage stamp. If you looked at an envelope where the postage stamp would go in the corner, that's basically what she owns, is that little square.
But does she have a piece of property on it, or does she have a structure
No,
on it?
it's all vacant. No, she has nothing on
thank you.
it.
That was
I'm sorry. I didn't understand.
No, thank you. I
No,
appreciate
that
it.
was torn down, from my understanding, 20 years ago.
Okay.
And it's just a vacant little square that is nothing.
And is there an alley behind?
Yes, ma'am.
And is it an active alley?
Nobody uses it for anything. I don't know if anybody owns any piece of it, but I think it's an open alley that the city still owns.
Okay.
It's not part of the property.
Thank you.
Go ahead, Mr. Feldman.
So I don't know if this might be for Ms. Mead. Is there any easement on the applicant's property? There's a reference to it in this opposition letter.
Roberta Mead Curry, Planning Design and Development Coordination. We have done just a cursory research of that.
Mhm.
There is a deed on the Hillsborough County property records that we've looked at for both these parcels, and I went back just a little bit. I'm not a title person, but there's no reference in the deed to an easement.
Okay.
So if there's any issue with that, then it would be between the property owners.
Okay, thank you.
Roberta, does she still have access via the alley? Is that her access, her
The
legal
alley is-
access?
The alley is unimproved. Okay, it's not paved. It is open.
Okay.
Okay.
City-owned?
City-owned.
Okay.
Yes. If she would need access, she probably would have to be before you, but again, it's an unbuildable lot.
No, but I mean, she does have physical access to walk down, drive down the unimproved alley?
Correct.
Okay, to get to her property?
Correct.
Okay, all right. Anybody else have any questions? Okay, I have one for Mr. Fernandez.
Yes, sir.
Since you're tearing the house down, and I realize you're asking for the most you can get, which is the 2-foot rear to the postage stamp, could that be increased to 3 feet or 5 feet? Is there a reason it's got to be 2 feet since you're tearing the house down?
The reason, only because this is a house that we fell in love with. And it happens to be.
I can't see that. Can you put it on the overhead?
It happens
if
to
you
be
think
40.
it's important?
It happens to be without a rear porch and without the front porch. It happens to be 40 feet deep.
That is a beautiful home.
So basically, we said 40 because of this footprint. And yet, no, we're not tied to that, but we're in hopes that if we do get 2 feet to her line, and she can't do nothing with it, whether we get the variance or not, she can't do nothing with that property. But if she holds that property and nobody can do anything with the other piece of property, then she has kind of a foothold on dictating what happens to the rest of it. I feel like if we can get this variance granted, if you guys want to say 3 feet or 5 feet, we're fine with that. We'll just have to remodify the home or redesign the home. But if we do get close to her, I think that maybe she'll concede and say, hey, you know, I can't do nothing with this property and we want you to have it, kind of this situation. That's what I'm hoping. And I don't mean to be rude when I say this at all, but we're younger, and I think she's older in her, I know she's older in her age. So, there's going to come a time where she won't own that property anymore. It's either going to go to an heir or somebody else, and I'm hoping that we can then get that property in the future possibly and make it one lot for us.
Okay, well, the reason I ask, there are minimum zoning standards for
Yes, sir.
side yards, and they're typically in that 7-foot range because you need room to maintain access and maintain your home, let alone build it.
Absolutely.
I'm not sure how you build it with only 2 feet.
I understand, and we're
especially
flexible.
with any eaves and overhangs. She doesn't sound like the kind of neighbor that is going to let you get on her property to build the house.
No, I'm hoping that she'll take a take money for it and sell it. That's
Well,
what-
yeah, I mean, that's not our purview here, but I understand what your hope is, but we're dealing with the
Legality,
practical,
right.
you know, is 2 feet enough for anything?
If you grant us 30 or 5 feet instead of 2 feet, that'll be, you know.
Okay.
The most, we're asking for the most.
Yeah, I understand. All right, that was it. I don't have any other question.
Our footprint is what we're basing it off of. It's not like, oh, we want it, but I mean, if
Yeah.
we
No,
need
you've already
a 20
testified,
foot,
right.
if we need a 20 foot in the front, and we go 40 feet, that gives us 60. So it only leaves 2 feet to her property. That's right.
Correct. Okay. All right. Any other questions? Okay, you have 5 minutes for rebuttal, Mr. Fernandez.
I think I'm good.
Okay. Without objection, I'll close the public hearing. Board motion and/or discussion. Well, I'm going to throw a point out there. I'd be perfectly fine with a 3 foot because I think that's adequate room to build at least, but I'm not sure how you build it with only 2 feet. But you may not think it's necessary. Yeah, he said he'd be willing to increase it some. Anybody want to make a motion? Somebody who hasn't made a motion tonight. It's your turn.
I'll make a motion.
Mr. Pasteur is worn out.
Mr. Pasteur and Mr. Feldman have done it all.
Well,
Just
step
sat
up,
here.
ladies, come on.
Okay, I'll make a motion.
All right.
I move that the variance request for case VRB 2013, the property located at 2417 Thrace Street, be granted as depicted on the site plan presented at the public hearing for a reduction in the rear yard setback from 20 to 3, section 27156, with encroachment for eaves and gutters based upon the applicant presenting competent and substantial evidence in the record and in this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 2780 of the city code. Specifically that this lot is extremely unusual. It's like a rectangle with a square cut out of the southeast corner. In order to build anything on this property, one would have to have a reduction in the rear yard setback.
Okay, we have a motion for approval, changing the request from 2 feet to 3 feet, a 3 foot instead of 2. Is there a second? Okay, we have a second by Ms. Hurtak. All in favor say aye. Aye. Any opposed? Okay, you've been approved 6-0 at 3 feet.
Thank you, sir. Is there any, just so I don't know very much, is there anything I need to do to follow up with this?
You might want to take care of the pets that are in the cemetery.
You'll get a hold of me?
behind you.
Okay. All right, thank you. Appreciate you guys.
Yep.
Two more to go.
Okay, VRB 20-18.
Roberta Mead Curry, Planning Design Development Coordination. The address is 3003 West Bay View Avenue. The code section under review this evening is 27156. The applicant is seeking to reduce the front yard setback from 25 feet to 10 feet 9. The applicant is seeking to remodel and extend an existing front porch. The property is zoned RS60, and the Hillsborough County Property Appraiser's information is contained in your packet. Right-of-way transportation and natural resources has found it consistent. Natural resources had consistent with conditions. Zoning has found it inconsistent. Property appraiser's information. Variance map. Property is located here. West Bay View is along here. There's a PD to the rear. Majority of the properties are RS60. Front of the property. Looking west. front of the property again, more of a close-up on the front porch. And then looking east. Site plan, basically the existing front porch is here. The addition will come out to here. So RS60, the existing setback is 25 feet. So the existing house was built in front of that with the porch extension existing here. So they're adding on this pieces, these additional portions here. They would technically be able to come before you under a different provision in the code, which allows for front yard projections, which would be allowed to have an 8-foot front foot setback. However, they didn't even meet the way the house was built. They had to be here. They had to be before you. And I have nothing else to add. Sorry, take that back. I have one letter of support. That's all I have.
Yeah, just to clarify, in the RS60 zoning, that front yard porch exception that they could ask for would reduce the front yard setback from 25 to 17.
Correct.
Okay, all
This
right.
reduces it greater.
Right, okay. Applicant, please come forward, state your name, address, and if you've been sworn in.
Joanna Turpinning, 3003 West Bayview Avenue, and yes, I've been sworn in.
Okay, good evening.
Good evening. I wanted to concur generally with what Roberta said, and I just wanted to add some additional information, some background about the house, and also just elaborate on our hardship statement in the application. So as far as background, my husband and I have owned Bayview Avenue for about 6.5 years now. We live there with my toddler son and our rescue dog. The home was quite a mess when we purchased it. It's a 1925 house, and we purchased it in 2013. So we fixed it up over time. We love the home, we love the neighborhood. We have great neighbors, including Ted and Carol Connor, who submitted that email in support of this variance, and they live right across the street from our house, so they stare at our house on a daily basis. The one item that is really an eyesore is the small and crooked front porch, which, as I'll speak about later, and as I mentioned in our hardship application, it seems a little unsafe. It's crooked, it's built on different height blocks, so it's our dream to put a proper 1920s front porch onto the house, one that adds more curb appeal and is also more architecturally appropriate to the craftsman style of the home. So basically we'd like to vest the existing front porch as Roberta showed on the site plan, which I can, I didn't bring it up with me, but on the site plan, we would like to vest that porch and then essentially expand the porch westward a little bit. In order to do that, we need to ask for the front setback to be even further back so that the new porch will be in line. It'll essentially be in line with the current porch, where the current porch is, and then a little further westward. So as far as elaborating on our hardship statement, I would like to just show you a few other things. I don't know if you guys are going to be able to see this on the here. But these are some doodles I want to show you. Can I zoom this out? Let me see. There we go. And I prepared packets for everyone. I guess I can give one later to add to the record, but I'll go ahead and do this here on the projector. But you can see these doodles here are all over the front porch. We don't know what this is, if it's glue or something that the prior owners did. Here's another picture. We've tried to grind them off. We had a professional come and try to grind them off of the concrete, but they never came off, and we just painted over them, and we've left them for a while. But that's something that's unique to our front porch. I haven't seen any other front porch in our neighborhood with these strange doodles. So that's just one little detail that I wanted to point out. I also wanted to point out just some other houses on our street. We have a variety of homes on our street, as I stated in my application, historic homes and contemporary homes. But here's just an example of one historic and one contemporary home, both that have front porches that seem to suit the scale of the home better. This is a historic home here. And as you see, our new front porch will be somewhat similar. Our house is different than this house, but our new front porch will be a little similar, what we would like to have as that one. And then here's a contemporary home with a larger, nice front porch on it. In addition, I wanted to mention that in our hardship, I noted that this front porch that is on our home was on it when we purchased it. It's not something that we made. It's not of our own doing. And so this is a photo I wanted to enter into the record of the house when we purchased it in 2013. So you can see that the same porch is on there. I also wanted to, as I mentioned, the porch is crooked. And you can see here, here's just some examples of, these are these little wooden blocks that these Grecian columns are standing on. And you can see, I'll just push it up here. They're all different heights. This one is like 1 3/4. Here's one here that's similar. And here's one that's 2 inches here. And here's another one that's over 2 inches in height. So that's something that I didn't mention in my initial application package, or I may have mentioned it, but I didn't provide the photos. And then also I just wanted to, you guys have the aerial views and the site plan in your packet, and in my application packet, but I wanted to provide you with a rendering. This is a hand-drawn rendering of what the new front porch we're proposing would look like, which we think would be more suitable for the home and more architecturally accurate. So thank you. I appreciate your time and being late here tonight. That's all I have to present right now.
Okay, that completes your presentation?
Yes.
All right. Is there anyone in the audience that would like to speak on this application, either for or against? Okay, seeing none, board, any questions for the applicant or staff?
Just want to confirm, you're talking about an unenclosed front porch?
Yes.
And you would be okay with any conditions that it remain unenclosed in perpetuity going forward?
Probably, if you can just elaborate on what enclosed means, like screens or things like that. Is that what you mean?
Screens should be okay. I would talk to the staff about that, but I mean, you can't close it up. You can't make it air conditioned.
We don't
want to.
We don't want to do that. Yeah, this is what this
walls
picture,
and windows, that kind of thing.
Yeah, the picture that I put up here. That's what we desire. It would be an open front porch, you know, that you could sit on outside. Okay. Yeah, so I think we would be fine with that if you all feel that that's necessary.
Any other questions? That was my question. Okay, you have 5 minutes for rebuttal.
I have no rebuttal at this time. I just thank you all for hearing this matter today, and we respectfully ask that you approve it.
Okay, we'll move to close the public hearing. Board, somebody want to make a motion and or discussion?
I just have a question, I guess, for the rest of the board. If the proposal is to have a condition that it not be enclosed, what is the thinking or the purpose behind that?
Because there's different allowances for porches than there are for homes. And so if it was allowed to be enclosed, you could make it an extension of your home. And then you could technically even down the road come back and say, well, I also want my allowance for my porch too. But that really it's so that you don't extend your home past the threshold for a home, because a porch is allowed to go a little further in certain zoning districts.
Yeah, porches by definition are typically open.
Right.
And most neighborhoods like homes that have front porches. So
the city of Tampa is very lenient on porches, not so much. In addition to your house and the front of your house.
Right.
And if we condition it as unenclosed, it means that it's gonna basically stay a porch as opposed to, because remember, we're giving them the right to build up to this line. And yes, it's based upon the site plan, but if it wasn't conditioned as unenclosed later on somewhere down the line, walls sometimes find their ways up.
Yeah, and she even showed a picture of one of the older homes where that happened.
But see, that one looked like it had a screen on the top portion.
I think it did.
Yeah, but I think it had windows.
But we've seen this happen with carports, so almost every time with carports, we might propose a similar condition, and for the same reason, because then they could turn into a room of the house.
Okay. No, we're closed. Can't say. Sorry.
But legal questions can be referred afterwards.
Any other discussion? Okay, waiting on a motion.
I'll do a motion. I move that the variance request for case VRB 2018 located at 3003 West Bay View Avenue as depicted on the site plan presented at the public hearing for a reduction in the front yard setback from 25 feet to 10 foot 9 inches to remodel and extend the front porch with the following conditions: that it remain an open porch
on all sides.
On all sides. That said, variance as conditioned be granted based upon the applicant presenting competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 2780 of the city code, specifically that they want to just extend their front porch for use for
Practical use.
Yeah, practical use, thank you.
All right, we have a motion with a condition not to enclose for approval. Is there a second?
I'll second.
All right, we have a second by Ms. Long. All in favor say aye.
Aye.
Any opposed? Been approved 6-0. Okay, last but not least case, VRB 2019, last year.
Okay, Roberta Mead Curry, Planning, Design, and Development Coordination. The address is 61 Ladoga Avenue. Code section in review tonight is 27-290.3. The applicant is seeking to reduce the corner/side yard setback from 15 feet to 10 feet. The applicant is seeking to install an in-ground pool and spa. Applicant received a tree removal and pruning permit per TRE 19-1721 for the grand tree that you might see in some of the plans or in photographs. The property is zoned RS75. The Hillsborough County Property Appraiser's information is included in your packet. But not in mine. Property appraiser's information, each one. Page 2. Variance map, again, property is here in the corner. This is Formosa Avenue, Ladoga Avenue. All properties are RS75. Front of the property. Looking at the corner. Looking down Ladoga Avenue, again, still the front of the property. Looking south down Ladoga Avenue here. Looking down Formosa Avenue, the property in question is here. This is looking directly at the corner. And the grand tree that has the permit is this one here. Again, they're looking directly at the elevation that would have the pool. So again, the tree that has the permit, and this is the area that would have the pool. Just a little bit further down Formosa Avenue. Site plan. This is the pool in question here. This is the pool patio surrounding proposed patio. Wall being built, pool equipment. This is where the tree would be removed from. Natural Resources is here if you have any questions of them. And they have no further information to add to the record.
Okay, I've got a couple of questions for Roberta. The 15-foot requirement is based on a primary structure, not accessory structure, correct?
Again, the 15-foot is the corner yard setback for RS 75 district.
For primary?
For primary, correct.
Okay, pools are accessory structures, correct?
Per 27-290.3, in-ground pools must meet the primary setbacks.
If they're elevated, is that, if they're 12 inches or less, aren't they allowed a lesser setback?
Let me read it. Let me pull it up.
And maybe not, maybe that's the same for
Well, I
accessory.
don't have an elevation to what the pool is doing, and we don't have an elevation to the spa presented.
Okay, well, we can ask the applicant those questions, but I was just wondering if a raised deck was triggering this as opposed to a non-raised pool deck.
Let me look at the code, and I'll
Okay.
get back with you.
Then I have a question for Mr. Knox. Sorry, gotta make you get up one more time. I was just looking at what's in our package on the tree permit placard last August. And maybe it doesn't matter. The removal was based on Chapter 13. Was that code still in effect back then, or had the code not changed to 27?
That's August 2019, correct?
Okay, so it was still under 13? Chapter 13?
August 2019, you should be under Chapter 27.
Okay, well, maybe they made application before, I don't know, but yours is specific, the general conditions are citing Chapter 13. Does it matter, 13 versus 27?
In this scenario, for the tree removal, it's really about the mitigation.
Okay.
So that would be the primary concern.
So 27's mitigation will kick in. Is that correct? Or are you going to hold them to 13's, Chapter 13's mitigation?
If they're in August, they should be under Chapter 27. I think that what the placard is, it may be a placard that was still generating from the
A cell hadn't been updated
code.
yet?
Yeah, that's correct.
Okay.
And in fact, yeah, I think that's what the scenario would be for that one. It would be under Chapter 27 and not 13. It was just generated from the placard.
I don't know what those differences are. It doesn't really matter to us. I saw 13 in the date, so I didn't know if it mattered to you, Natural Resources, that is. But it doesn't sound like it does.
It does not, only in
Okay.
the sense that the placard would need to be corrected, that's all.
Right. Any other questions? All right, seeing none, applicant, please come forward, state your name, address, and if you've been sworn in.
I've got a difficult job standing here this late on these various board nights. Thank you all. My name is Joe Wright. I'm the owner of 61 Ladoga Avenue, Tampa 33606. I have been sworn. As we've talked about, I'm hoping to build a pool. We've gone through one part of the permitting process. We've already been granted the permit to build the walls and the pool deck. We're moving the driveway over a little bit. I've got this pretty fancy little thing here that y'all are probably holding. So can y'all see y'all's fine? You don't need this.
I think we have that site plan in our package.
Okay.
Yeah.
All right. Perfect. So one thing that I've had to do is I've had to move the driveway over to the right in order to allow enough room for the pool. But before I really get into the hardship and so forth, I kind of want to give you a little bit of background about the house. The house is a 1928 house. It was one of the first houses that were built on Davis Island. In fact, it was Mr. Davis's model home. It was called the Tribune home, which is pretty cool. It's only had 3 owners since 1928. I'm the third owner. Previous 2 had been there for 40 and 50 years. It's a very unique home, and one that when I purchased, it was there were 2 offers. One was my offer, which my intent was to renovate and remodel the home. The other was to knock it down. It's a beautiful home, should not be knocked down. So everything that I'm hoping to do is in keeping with the architecture of a 1928 type home. With that, there was an article in the Tampa Tribune that came out this week that said there's only roughly 80 homes left on Davis Island that were built in the 20s and 30s, which is pretty. It's an interesting fact, but also a concerning fact. Getting into my hardship, the home has a detached garage that's connected to the main house via a breezeway. And it's not a typical home that will have a front entry garage or a side entry garage. Because it is at the rear property line, the driveway leading into the garage has to run the length of the rear of the property. Obviously, with that, I'm not able to place a pool in the backyard because I don't really have a backyard. So that's my hardship. What we're asking for, according to this plan and according to the permit that I have in hand, is the only area that's affected by this permit is the hot tub / spa area. Everything else in the plan has either the permit's already been approved, or it's the pool that's set outside of the setback area. With that, I look to see what we're talking about in terms of square feet for the hot tub, because that's really all this comes down to, and it comes down to about 52.68 square feet. To put some numerical numbers on that, 52.68 square feet is about half the size of a Toyota Camry. I went out and measured one today. It's also smaller than the size of a queen-size comforter. So we're not talking about a whole lot of space, which is what I'm needing in order to obtain this variance. Outside of that, I'm open to questions.
Okay, does that complete your presentation?
Yes, sir.
All right, is there anyone in the audience that would like to speak on this application, either for or against? Seeing none. Board, or you want to answer my last question for me? Thank you.
Hopefully you can see this on the screen. Okay. So this is section 27-290.3, swimming pool. So if you see this paragraph here, and if you read the last line, a rear lot line, let's see. Pool shall be located a minimum of 5 feet from any side or rear lot line and no closer to the corner lot line than the corner yard setback established in 27-156. So the corner yard setback for a lot that's zone 27-75 is 15 feet.
Okay, so which is the same as the primary residence.
Correct.
Okay, all right.
Okay.
Thank you very much. My question for the applicant, is this pool deck 12 inches or less? above
Yes.
ground?
Yes.
Okay. I have no other questions. Well, yeah, I do. I'll ask the obvious one. Why can't the spa be positioned somewhere else?
Yeah, well, one of the challenges that we faced is if we place it on the here, if we place the spa over here, then you get a little bit too close to this covered entry, where you don't have space to really walk through in order to get into the side door here. Over here, I spoke with the pool guy, and his description was due to where the pool equipment is, that it's possible that the jet propulsion wouldn't be as strong as it would be if the pool equipment was closer to the spa. So he thought that'd be the best place for it, and architecturally, I think it is also. And that's one thing that is very important to me is to build a pool and a spa, if this is approved, that's in keeping with the house. It's something that I want proportionate to the house. It's something where with a 1928 house that's been meticulously maintained, it's important that you get it right the first time. This is a property that if I'm lucky enough, I'll own it for 40 or 50 years like the preceding owners have owned it, and I'm hoping that I can enjoy it with a spa attached to the pool in a location that makes sense.
Any other questions?
Yes.
So
I have a question. I'm looking at this, and I see where your spa is, and then over to the left of it, or what would be west of it, there's a little square that says new pool. What is that?
It's new pool equipment.
Oh, equipment. Okay.
Yes, ma'am.
Never mind. That's what
I think it just says EQ, so.
Could
yeah,
be.
Yeah.
I can't read it.
And it's fuzzy.
That's fine.
Mr. Pastor?
So I generally think people should be able to do what they like with their property within reason, and certainly if you've got space to add a pool, that's a reasonable thing to do. But you know, our job here is to look for the hardship that exists on the property, and it didn't surprise me when Ms. Mead said that there's no exception on the corner yard, because that's the one yard that's pushing up against the road, closest to a road. Of course, the front yard faces a road as well, but it's a lot further away. So it's not surprising to me that they don't want buildings or pools getting closer to a side road yard. So, you know, the idea of what's a reasonable layout or size is subjective to everybody, but my question would be, you know, does the pool have to be as big as it is? You already addressed the location of the spa. I'm looking for something on this property that would dictate the need for a pool to be as large as it is or laid out in the way that it is. I know you said architecturally. I'm an architect. I see a number of ways I would do it differently. But that's all subjective, of course. So in the realm of what would compel us to approve a variance to allow a pool to get closer to a roadway that's clearly being dictated in the code as something that they don't want to allow exceptions into, what is the compelling argument for that need?
Okay.
Because you said, you know, it's 52 square feet or whatever it is and how small that is, and so by contrast, that small amount could be shuffled elsewhere on the deck with the issues you already pointed out.
Okay.
Or shoved into the footprint of the pool, integrated into the footprint.
And if I could have done that, and if I felt that it would be in keeping with the proportion of the property and the area with which the pool is located, I certainly would have done that. These are all things that I've thought about long and hard before I got here. I'm not going into a project of this magnitude without really thinking things through. One of the challenges is that if you take the spa and you say, okay, we're gonna push it in, or we're gonna make the pool that much smaller. One of the problems that you run into is you run into what we can make the depth of the pool. These are all things that I've learned as I've gone through the process. You guys are certainly more knowledgeable about this than I am. But one thing that I learned is with the grade of the pool, the first third of the pool I guess the way that it works is it can angle it at this level to a certain level, and then the second quadrant, the second third quadrant is the quadrant that angles down, and then the final third quadrant is the deep end of the pool. And by making the pool a little bit shorter, it doesn't allow the kind of play area in the first third quadrant of the pool that I'd like to have. That would be kind of, again, my thought of doing everything that's in keeping with what's proportional with the property. I also want a little bit deeper pool. I don't want a 6-foot pool, which is basically what that would create. I've got a 9-year-old son that no matter how many times I say don't dive into the pool, that's what 9-year-olds do. They're going to dive in the pool, and I don't want them diving into a pool that's 3 feet in the shallow end, which more or less is what that may create if we have to push this in a little bit. The other few things that I wanted to point out is on the back end where the wall is, you're not going to be able to see the hot tub from the street. Additionally, all the neighbors got a great relationship with all the neighbors. None of the neighbors had an issue with any of this. I went out of my way to go and meet personally with every one of them. Talked with them about the plan. Walked them through what the plan meant, what it meant to them to what the project was going to look like upon completion. Just a lot of the miscellaneous concerns that they may have. One thing that I know they've appreciated is the transformation of the house over the last 2 years. Certainly, you can look in before and after pictures. The pictures of the exterior of the house alone when I bought the house in February of 2018 versus what they look like now. It's my intent just to continue to improve the property, and I'm afraid if I made the pool a little bit smaller, it's going to be disproportionate, and it's not going to be in keeping with what I feel the pool should be like on a property like that.
Any other questions?
Do any of your neighbors have pools?
Every one of them.
And how big are their pools? The same size, or are they bigger?
Where my property is on the island, we have probably the largest lots anywhere on the island, or at least in that area of West Davis, and so I can't tell you that they're larger than mine, but or what mine would be if this is approved. But they would be larger than say a pool that was on a much smaller lot. Keeping in mind because the lot is almost a double lot, I'd hate to put a little bitty skinny narrow pool on such a large lot, given the fact that that's the only location that I can put it. Where the garage is and where the driveway is really limits me on where I can put it. Otherwise, I'd do something else. Again, I've thought about this a lot. I've talked to the architect, and this is the best plan that we can come up with.
Any other questions? Okay, seeing none, you have 5 minutes for rebuttal.
I think I'm good. I appreciate it.
Okay. Without objection, I'll close the public hearing. Board, is there a motion and or discussion? You're going to make a motion?
Sure. You got my magic words. I move the variance request for case number VRB 2019 for property located at 61 Ladoga Avenue be granted as depicted on the site plan presented at the public hearing for a reduction in the side corner yard from 15 to 10 per section 27.156, 27.290.3. To construct an in-ground pool and spa, based upon the applicant presenting competent and substantial evidence in the record, and that at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 2780 of the city code, specifically that there is no other place on this property for them to place pool, the semi-detached garage, and the irregular, what do I want to say, irregular building on the property, leave it so they have no backyard, so they want to put it in the side yard.
Okay, we have a motion for approval. Is there a second or discussion?
I understand everything presented, but I just can't support it. I think that there's a number of ways to address it. The pool doesn't have to be as large as it is.
Mr. Chairman, before there's discussion on the motion, there needs to be a second.
Okay,
I don't know if we have a second.
I do not second.
Yeah. Is there a second on the motion?
Second.
All right, we have a second by Ms. Walker.
And
now discussion.
I think the spa could be placed on the west side and the pool shift to the east, and you'd have the exact same pool with the depths required, and you'd get the jet pressure because it'd be closer to the pool equipment. That's just one of the several options I see. I don't see a compelling reason that we would project closer to the road to make a pool of this size with this layout when there appears to be plenty of deck space to work on this plan.
I tend to agree.
Mr. Feldman, do you have any question or comment?
No.
I just want to make perhaps just one comment. So I think that one of the, I guess, hardships that the applicant runs into is that this is a corner lot. And had this not been a corner lot, my understanding is that, this design would be acceptable. I also think that it's in harmony with the Tampa Comprehensive Code because, as the applicant points out, Davis Island is developing, and pools are very common just within Tampa generally, but particularly on Davis Island, where the homes I think tend to be a little bit more have more amenities, and so I think that it conforms to the current criteria.
Based on the evidence that I heard tonight, I agree with Mr. Pastor. There's plenty of room around this pool, between the pool and the house. The applicant testified he's on a large lot. He has something that is unique from that standpoint, and yes, I understand that making this pool as large as possible, which is pretty much what he's asking, without going even closer to the road, isn't really a hardship. The pool equipment location, there are other places for that, but regardless of the pool equipment, the spa has several different optional locations, keeping the pool the same size, just reducing some of the deck. So I didn't hear any compelling argument for going closer to the road.
Well, since you've raised that issue, and given the objections that I've seen, I will voice my opinion on this. I agree with Ms. Walker that what we have is a corner lot that ends up getting squeezed. I also agree that there are other ways to situate, to design this pool that could work within current setbacks. I don't like to get into the business of redesigning people's projects. It's not really my intent to say, well, I would do it this way or I would do it that way. It's their property. I would say let them do it the way they want to do it. Provided we can accept the fact that there are hardships. this one is not a hardship case, it's more of a practical difficulty situation. You've got an existing layout of a home, you've got the driveway, which is going to be modified to some degree just to make this pool fit. Look, it could really go either way, but what I see here forming up is a 3-3 vote that's going to end up with the applicant getting continued and coming back and having to redo this over and over again. So, being on the fence, what I'm going to do is lean towards the denial route so that the applicant can then take it and do what he needs to do, as opposed to repeatedly going through this process on a 3-3 vote. It could go either way, and I do see ways to get around this, but I think that to me, the best result for the applicant is to have some definity where he can move forward and decide how he wants to do it with that. And with that in mind, I think I'm going to lean towards a denial and say there's other ways to figure this out.
Ms. Long?
Mr. Pasteur recommended that he put it on the west side. That's their front yard.
I didn't recommend that. I said that that's one of many options, and it's still behind a fence, so it doesn't matter.
I think what it means is just shifting it over, just instead of having a
Are you talking about the spa or the swim?
The spa.
Oh, I
Just
thought
the
you were talking about the whole
spa
swimming pool. I'm sorry, I misunderstood.
You'd end up with the exact same number of gallons of water in a different shape.
Okay.
Any other questions or discussion? All right, we have a motion for approval and a second. All in favor say aye. Aye. Opposed? Nay. So you've been, well, now we have to have a motion. We need a motion now for denial. So would somebody like to make that motion?
Roll call on that.
Pardon? Oh.
Nay.
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 Nay. Aye.
4 to 2.
4 nays and.
Oh, wait, so we approved. Excuse me.
No.
Oh.
Motion to approve.
Wait,
The
never
motion
mind.
to approve failed.
Nay, 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 yes, yes. So yeah, we need a motion for denial. Somebody like to make that motion?
I'll make the motion. Move that the variance request for case VRB 20-19 for the property located at 61 Ladoga Avenue for a reduction in the side corner yard from 15 feet to 10 feet, section 27-156, 27-290.3, be denied due to the failure of the petitioner to meet its burden of proof to provide competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria as set forth in section 2780 of the city code, specifically that there are multiple ways that you could put the spa in that don't encroach in the side yard.
Okay, we have a motion for denial. Is there a second? Second by Mr. Pasteur. All in favor of denial, say aye. Aye. Any opposed? Aye. Okay, so you've been denied 4 to 2.
Thank you, Ice.
So you can't appeal to city council. You have 10 days to do that. And city council can justify why the rule is the way it is. Thank you, board. We are adjourned.
You guys can do